next one is the defendant's demand for specific discovery regarding Trayvon Martin's phone. Same issue? Different dates?
Not exactly the same issue, but it's related. The phone was, Mr. Martin's phone was difficult to access for quite some time. We learned through discovery that limited data was obtained by an FDLE analyst sometime in March. It may also have been March of 2012. It may also have been obtained by the Seminole County Sheriff's Department, but then if we fast forward to September, when we received the analyst's report and ultimately took his deposition, we learned that he was unable to access the internal memory of the phone. I guess we'll call it the flash memory. And that's because the phone was locked up. Not that it wasn't operable. In fact, we knew that it turned on because we had seen that. But Mr. Brenton indicated that he could not access any more than what he already had because the swipe code or the password was not available. Efforts to obtain the password or the passcode had been unsuccessful through family members or through other forensic techniques. We also learned in probably late November, early December, that the phone had been removed from evidence from FDLE, provided to an investigator with the state attorney's office who shipped it to California, where additional information was obtained. We were told that that information, other than obtaining the swipe code, which was a big plus, nonetheless the data itself had not been, was not subject to analysis. Fast forward yet again to early January of this year, there is a well-known forensic outfit called Celebrite that provides software to law enforcement agencies and others who believed perhaps they could now access the phone. Mr. Brenton, with our knowledge and an invitation to participate, took the phone to New Jersey, where, January 13th or 14th, the phone was downloaded. And that generated two things. It generated a report from Mr. Brenton dated January 14th. That's a hard report that identifies all of the data on the phone. It picks up phone numbers and text messages and contacts and such. We were promptly provided that within a few days. However, we were not provided the data itself. We were told that they had been successful at downloading it. We made some requests for that, and in late February, February 22nd, I believe it was, we were provided with a disk containing the data files, known as bin files. We also got another report from Mr. Brenton, but we were told that was simply another formatting of the first report, that it did not contain any additional information. So that's where we were as of the end of February. We've not received any additional reports since the end of February regarding the content of the phone. We don't know if the state has received any additional reports regarding the content of the phone by Cellbrite or someone else, or if Mr. Brenton has been able to recover additional information from the phone, whether there's been an oral or written report. What sort of brings this issue to the forefront is during depositions last week, one of the witnesses was shown an extract report of her text messages, and she commented that it appears as though there are text messages missing from her report. She didn't quite know why, but she was confident that the first several days of information on her phone, actually it would have been on Mr. Martin's phone, reflecting his communication with her, were not there. She offered no explanation that was helpful in any event. So, since the acquiring and analysis of the data is somewhat fluid, depending on parameters that are entered in the software and the plugins, as I'm beginning to understand it better, and having not received any updates since January, and also learning that there may be some things missing. Of course, it's hard to know what you don't know, but we know at least there's that. So we're asking the court to direct the state to provide us with any additional information from whatever source, whether it's through an oral report or a written report or any way in which they have learned there is additional information on Trayvon Martin's phone that was not included in Steve Brenton's reports of January 14th.
For the February 22nd data, you said you were given the data from Cellbrite on February 22nd.
On February 22nd, there was a slightly reformatted report that didn't contain new information, and there were the data files. The data files are not of value unless they are analyzed through some sort of software. So in and of itself, just having the data files is not of value to counsel. If that data has been accessed and there's additional information gleaned from it that the state is aware of, then we want to have that.
Thank you. Who's responding? Mr. De La Ronda?
Your Honor, as Mr. West mentioned, the state has provided, as far as we know, everything we've gotten. We've not just provided the CD originally, but also a list, and the defense filed a motion, and I responded on February the 8th, detailing exactly what happened to the cell phone, where it went, who dealt with it. We provided the data, and the expert, Mr. Brenton, has been deposed twice regarding this issue. He specifically told them, here's all the data, you can have your expert look at it and determine what he wants or doesn't want, wants to pull out. So they wanted it in that format, that's what we provided it to them. We cannot provide anything else other than what we've provided through FDLE. Mr. Brenton has been deposed twice. Mr. West is correct in the deposition where that witness did mention what Mr. West said. Those were documents, by the way, that Mr. West showed the witness based on what was provided by the state to defense, and they were able to show the witness. So what we've got, provided to the defense in all formats, including flash drives.
And if you receive any new information that is not previously provided, it will be provided within 24
Yes, Your Honor.
hours.
We'll prepare a proposed order. I don't want to get too hyper-technical here, but did Mr. De La Ronda say they have not received any additional reports, oral or written, or additional information from the phone since Steve Brenton's report in January of 2013?
I'll be glad to answer that, Your Honor. I honestly don't remember off the top of my head right now when his second deposition was, but I know at the second deposition more information was provided to the defense, and that's why they deposed him again. So I don't know what date Mr. West refers to, but in addressing the court, I provided everything, including up to the second deposition. He hasn't been deposed yet, and I haven't since that time, and I haven't talked to him since that time.
I would like this to be very precise. I'm sorry to drag this on. We deposed Steve Brenton in September of 2012, where we got his first report for the first time. That had been generated in March. We learned that he'd even done an analysis by accident when he happened to wander into the evidence room at FDLE when we were inspecting evidence. In October, we know the phone, without our knowledge or consent, was shipped to California, but new data was recovered.
I need to know the date that you say that you last received any information regarding this issue.
The report was January 14th, updated September 22nd, roughly 2013. January 14th, 2013, February 22nd, more or less, 2013, when we finally got the bin file. as well. There has been no updated reports, written or oral, since then.
Thank you. Have you received any additional information regarding this issue since the information provided on February 22nd, 2013?
If that is the date of the deposition, no. If the deposition occurred, the second deposition occurred after that, then yes. So I'm just trying to answer it and be accurate.
Do you
I don't
know the
when that-
date of the second deposition of Mr. Benton? Just that question.
No, I don't know precisely. We had asked for the bin
That's
file.
easily ascertained, so the response from the state is that they have not received any additional information, oral, written, or otherwise, that from Mr. Benton or Cellbright since his last deposition. So that date is easily ascertainable.
Yes, we would also include any other person that may have given them that information, not limited just to Cellbright.
Have you received any information?
No, we have not talked directly to Cellbright.
Or anybody else?
No, Your Honor. No.
Okay, thank you. Then the next one is the defendant's unredacted motion to allow additional witness disclosure. I missed one. Let me go to this one. Defendant's demand for specific discovery regarding any enhanced or edited or cleaned up versions of any and all 911 calls listened to by Tracy Martin in this case. Who's arguing that? Mr. West?
Again, this is mostly for clarification because there's confusing information that we have learned or have been provided. A very brief history for context. As the court may be aware, several residents from the retreat at Twin Lakes called emergency services upon hearing some part of the events of February 26th. One of the residents called and was connected fairly early in the sequence of events. After the event began, but before the shot was fired. So there's about 40 seconds of recorded 911 call before the shot is heard. During that time period, during that 40 seconds, there are a number of what have been characterized as screams or cries for help that are heard clearly in the background. That recording was played for Trayvon Martin's father, Tracy Martin, about February 28th by the Sanford Police Department. It was not made available to the general public. Testimony from police officers were that when Mr. Martin heard the recording that contained the screams and the shot and was asked by the investigator, "Is that your son?" he said no. Fast forward a couple of weeks or so, there was an event where, over the objection of law enforcement, the mayor, with the agreement apparently of the city manager, assembled Mr. Martin's family and council and played that recording as well as some others. Around March 17th, I believe. Law enforcement was not present, and all of the family members and council were in the room together hearing these calls, all but for Tracy Martin hearing them for the first time. There were various reports about what was on the recording. Frankly, statements made that are absolutely forensically untrue. For example, 2 shots as opposed to 1. We know that just didn't happen. And some other observations. However, in response to Sanford police investigators saying that Mr. Martin did not identify his son's voice when he heard those cries for help, it was reported in the newspaper, and the quote attributed to the family attorney, Benjamin Crump, that Sanford police was lying about that, and this is the important part here, that since that time, the tapes or the recordings have been cleaned up, and that now Mr. Martin is confident that it was indeed Trayvon Martin screaming for help. We've been trying to get access to those cleaned up recordings. We don't know yet whether there were cleaned up recordings, whatever that means, played at City Hall for this assembly, whether Mr. Crump had cleaned up recordings that he played for Tracy Martin at some point. That doesn't seem likely just because of the timing, or what it was he meant when he said Tracy Martin has listened to cleaned up recordings and now he is confident it was Trayvon Martin. So we want the answer to that question.
So the bottom line is that one particular 911 recording, has that recording been cleaned up or enhanced? Mr. De La Ronda?
For the record, I am not Ben Crump. I was not present when that was
Well,
done. And so I'm not aware of it. I wasn't present when I was done. I provided.
To me, the background information, I've heard it over and over again. What I want to do is to get to the crux of the issue. So the issue here is that one particular 911 call from a witness that has cries or screams for help on it that was somewhat hard to understand. Has that one recording been cleaned up, or enhanced, or edited? Let's start with cleaned up.
Cleaned up. There are experts that are reviewing it and doing analysis on it. At some point there may be. That has not been played for Mr. Tracy Martin. So to answer the specific court's question regarding this motion, we have not provided Mr. Martin, Tracy Martin, a cleaned up version. I think there is confusion by Mr. West in terms of when the recording was played, apparently at City Hall, maybe they had better equipment so they were better able to hear what was being uttered in that 911 call.
Okay. So it's being, at this time, it's sent, where is it?
It's, well, a copy of it was sent to, and Mr. West is aware of it in terms of experts that have been listed by the state. And so, but that has not been played to Mr. Martin at all, to Tracy Martin.
So a copy of the 911 call is with an expert to be cleaned up or enhanced?
If possible, yes, Your Honor, if possible.
And it is not going to be edited, is that correct?
They will do whatever work they do, the experts do regarding that, and obviously they have been listed, the experts have been listed by the defense, such as the defense has their own experts. We don't know what their experts are, but that's been provided.
So a cleaned up, edited, or enhanced version of that 911 call has not been provided to anyone?
That is correct, other than the experts are doing whatever they're doing.
Other than
with
the
it.
experts?
Yes, Your Honor.
And when you get your cleaned up, enhanced, and/or edited version, you will provide a copy to the defense within 24 hours. If the defense has their own experts that are trying to do the same, they will provide that information or report to the state within 24 hours of receipt.
Yes, Your Honor. We've already, just so the record's clear, there's two experts that have already been, their reports have been provided to the defense and they've already been deposed. So there's one additional expert, or two additional experts.
Your Honor, with all respect, that's secondary and not really related to the issue as to what happened last March. The statement that was reported was attributed to Mr. Crump that there was a cleaned up copy that Mr. Martin heard. Apparently the state has not inquired of Mr. Crump whether or not that copy exists, or what did he mean by that when he said to the paper, there's a cleaned up copy that Mr. Martin has listened to. That's what I'm trying to get to the bottom of. The state has been aware of this for some time. If the state won't inquire of Mr. Crump, perhaps the court will, just to find out.
No, you have in front of the 50CA the motion to determine whether or not they're going to allow you to depose Mr. Crump. I have ruled on that issue. We will await their response. So you have been told by counsel that they have not provided to anyone a cleaned up, edited, and/or enhanced version of the 911 tape. The copies are, copy of the tapes are in the hands of experts for both the state and the defense to try to do that. If reports are received that have not already been sent to the other side, they will be provided within 24 hours. Is there anything else regarding this demand for specific discovery?
Only that we would ask the court to direct the state to inquire of Mr. Crump whether there is in fact a cleaned-up recording that was available to Mr. Martin in mid-March. And
The state has already indicated that they have not provided a cleaned-up, enhanced, or edited copy to anyone, and the only copy that they've given is to the experts to try to do so.
Yes, Your Honor. In fact, when this took place in mid-March, Mr. Delarionda's office was not yet appointed. The question is, did Mr. Crump have a cleaned-up tape that he played for Tracy Martin? And I'm asking the court to ask Mr. Delarionda to find that out.
If you'll read the rules that I provided you in the front, that once the court rules, there will not be argument about the issue with the court. So as far as I'm concerned, that issue is concluded.
Thank you, Your Honor.
Thank you. The next one is defendant's unredacted motion to allow additional witnesses' disclosure. Who's arguing this?
I will, Your Honor. Thank you.
Thank you. Okay, and you've listed 5 witnesses that you would like to disclose past the disclosure deadline.
Yes, a moment, if I might. If I might, Your Honor. We are intentionally cautious with witness identification, so I'm going to be similarly cautious in why I want them. But Mr. Delarionda, I think, would agree that under what you have in front of you, the unredacted, D and E are 2 witnesses that were most recently identified through ongoing discovery. They are potential state witnesses. They had contact with the witness who was on the phone with Trayvon Martin and were there for some of the foundation of her testimony. So maybe if we split it up, the state may not have any concern about those 2, and then we'll go up the list.
Okay, well, let's first find out if they have any objections, other than not timely filed. Let's go there first.
Does the court want me to address D and E first, or just
No,
overall?
just all of them in general.
In general, I would just like to know who A and B are to have a better understanding of who they are. Under
Hey,
the
would you
list
like
of-
to have a short conversation about it, or?
And the reason I asked is under the list provided, it was just listed their names, care of OLG. And so I'd like to have a little bit more information. Mr.
Maybe a
who
moment.
gave you this?
I'll
Regarding,
just stay here if you'll go to
Sure.
council table.
Right here, I think
That's
might work.
fine.
yeah. Do you have a report?
So I think we've now identified, and his objections will be whatever they are.
I guess to answer specific court's question, I've been informed about A and B. A, I'm a little concerned about the evidence that this witness will provide. I'd like to have it in a timely fashion. Apparently, there's new evidence that this witness is going to do. And I'd like to have some understanding of when that evidence will be available so that I may depose this witness. And the other caveat I would ask is if this is going to apply to defense, then I would like to have the same opportunity if I need to respond. I hate to keep going, but we should have the same opportunity. If that should arise, is all I would request.
Okay, so witnesses listed as A, B, C, D, and E. I will allow them to, the defense to add them to the witness list. As regards to witness number A, any reports that you receive will be provided to the state within 24 hours. And if they're not able to have enough time to subpoena them for a deposition, you will make them available for a deposition.
Absolutely.
If the state finds after that that they need to add witnesses to
Counter.
respond to these 5 witnesses, they may list them with the same caveats that you provide any documentation that they provide to you and make them available for deposition.
Thank you, Your Honor.
And pursuant to a previous agreement by the state and order from this court, I think the way we did it was the opposing party would have 7 days to review and decide a responding witness. So that might be an easy way to keep it organized. Is that okay?
Is what Mr. O'Mara is saying is giving me 7
Yes.
days? Okay, I take that. Thank you.
Okay, thank you. Then we get into the other, maybe it would be easier for me to first take up the state's motion requesting court inquiry of defendant regarding defense counsel's waiver of any proceeding to invoke immunity.
Sure.
Okay. Without objection, I think it's a good idea if Mr. Zimmerman would stand up and raise his right hand. I have a few questions to ask him just regarding that issue.
I don't think it's appropriate, Your Honor. So let me present my sort of side of things. The 776.032 allows for an immunity to be requested or asserted by the defense. Traditionally, that is done pursuant to 3190, which allows for a pretrial determination of those issues. And for efficiency, and quite honestly, in most cases, it makes sense. Why go to a trial if you can address and resolve the issue ahead of time? Because, as I've mentioned to you in a previous court hearing, the unique nature of this case, and because of the way we've decided to handle it, that we would much rather have a jury address the issue of criminal liability or lack thereof. Having said that, there is nothing in the case law, there is nothing in the statute, and there's nothing in the rules that would suggest that that issue has to be heard pre-trial, or that the defense would need to preview any strategy that it might have to the court or the state. There are two concerns with that, so if I can address them, and I think the state will have their response. The two concerns are this. Is one of the parties somehow prejudiced by the idea that the defense would maintain the right to present that argument to you during the trial or at the end of the trial? Here are the two concerns. Procedurally, generally speaking, under a motion to dismiss, we carry the burden to prove, preponderance of the evidence that immunity should be granted because we've proven that Mr. Zimmerman acted in self-defense and was reasonable in doing so. I know you're well aware of the standard. I've read some of your orders in that regard. So the procedure is an issue. However, since this is a hearing that is solely for this court to decide, and you would only decide it at the end of the presentation, if we were to do this, then we were to do it certainly not at the end of the state's case, and at the end of the defense case, and quite honestly, it would properly be at the end of the state's rebuttal case. We might come to you and say, we'd like you to consider 776.032 immunity. So do what you can.
Those are the might things, and I'm
Right.
not arguing with you on those. But I understand the state's reasoning because of potential 3.850 issues. I think that there are certain questions that I will limit. If you have an objection to the question, I will hear your objection at the time that I ask it.
May I respond to that? Okay. The concern over whether or not I am properly and effectively representing Mrs. Zimmerman is an issue that this court both can and usually does address at the end of the trial. So here's my response to that. Not to preempt my client's right not to testify, not to preview his strategy today. At the end of the...
I'm not previewing a strategy.
Well...
I'm going over what has been done.
Okay.
Not what's going to happen in the future.
Okay. And just to finalize...
I will allow you to object and hear your objections and may not ask the question.
To the extent that the state has a concern over my ability to properly present my client on appellate issue review, I think this court can address that not now, but you can address it at the end of the trial. When you ask Mrs. Zimmerman, example, Mrs. Zimmerman, you have continued to waive. Do you understand? And you would go through that inquiry.
I haven't heard him waive.
I'm sorry?
I haven't heard
No,
him waive.
but you can ask him that at the end of the trial.
Well, in all the criminal trials that I have conducted, I do ask the defense before and during the trial whether or not there are any other witnesses that you want your attorney to call. Were there any other issues that you wanted your attorney to bring up? Are you aware that your attorney is arguing that to the jury a lesser included offense and is admitting to that? Those types of issues. Sure. That they'll come up later, that any defendant says, I never knew that.
Okay.
So that's the type of issues, the questions that I'm going to
Then I
ask.
apologize, because I may be believing that there's more to this than there is. Is your inquiry...
Object, feel free to object.
Is your inquiry going to be limited to whether or not Mr. Zimmerman has not asserted his pretrial right to an immunity hearing?
Absolutely.
I apologize. I've spoken too long and preemptively. So
That's okay.
as to that issue, if I could have just a moment.
Yes, you may.
Sorry, Your Honor. Couple of responses. One, I think it should be done in camera, so I would ask that it be done outside the presence of the state and outside the presence of the media. I think it is I understand your concern. I consider it to be at least preemptively addressing an issue that attends to strategy. And I would be more willing to address that with you in camera.
If counsel will approach, I'll tell you what I'm going to ask him.
Okay?
Court will be in recess for 5 minutes.
United States won't return to order.
Please be seated. Could you let Mr. O'Mara know that we're back in session? Somebody?
Thank you for the recess, Your Honor. I'm going to try one more alternative before a court inquiry. I am concerned that though it's very understandable because it is a significant pretrial right that may be being non-asserted, I would ask that if I would prepare an affidavit for my client, and I would further ask, I know that you have a list of questions you would want answered, that I can incorporate those questions into an affidavit from my client, present that to the court. If at that point that is not sufficient, then we would have court inquiry. I can accomplish that in a couple of days, and I do think that we'll be back before the court soon. So rather than a public and somewhat invasive inquiry regarding a number of the reasons for the decision not to assert a pretrial hearing, and that is my concern, that those reasons, which may be a basis for why Mr. Zimmerman made his decision, we cannot go into. So
I'm not going to ask a question that requires an answer other than yes or no.
would the court consider an affidavit?
The only problem with that is part of what the court does in trial and through hearings and stuff is to look at the demeanor of witnesses who are testifying under oath to make a determination. And That's part of my job.
And of course, part of my job is making sure they don't waive any of Mr. Zimmerman's rights, one of which is inquiry of the court a month and a half before trial.
Well, if you object to any of my questions, I will allow you to state your objection, and I will rule.
Yes, Your Honor.
Thank you. Mr. Zimmerman, you may stay where you are, but if you'll please stand up and raise your right hand to be sworn.
Do you solemnly swear or affirm that your answers to the first questions will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, and you are George Zimmerman, and you're represented by counsel in this case and have been since at least the time of your arrest. Is that correct? Right, and counsel is here with you today. The state of Florida provides a procedure whereby you may file a pre-trial motion for immunity. And at that motion hearing, the defense bears the burden of proof. Do you understand that?
Your Honor, one objection. I contest that it is merely a pretrial event.
The state does provide for a pretrial event. Do you
Yes,
understand that?
Yes,
Okay. And are you familiar with Chapter 776.032, and that's known as the Stand Your Ground statute, or the immunity statute? Are you familiar with that statute? Okay. And without telling me any substance of any conversations that you've had with any of your lawyers, but have you had conversations with them about filing a immunity motion and having a pretrial hearing? And are you aware that counsel had previously stated that they were going to file a motion, a pretrial motion, and request a separate immunity hearing? Okay, and that the court had set a deadline for filing any of those motions in a previous court order, and that was April 26, 2013. Are you aware of that?
Yes,
And in addition to that, that the court, in anticipation, had set aside 2 weeks in April for an immunity hearing. Are you aware of that? And then prior to that date, counsel announced to the court that he will not be filing a pretrial immunity motion. Are you aware of that?
Yes, sir.
And that was discussed with you?
Yes, sir.
And you're also aware that no such motion has in fact been filed, is that correct?
Yes, sir.
And that matter was discussed with you also.
Yes, sir.
Do you consent to counsel's decision to not file a pretrial immunity motion?
Yes, sir.
And do you consent to counsel's not requesting a pretrial immunity hearing?
Yes, sir.
Is it your decision not to file the pretrial immunity motion?
Yes, sir.
Is it your decision not to have a pretrial immunity hearing?
Have a moment.
Thank you, Your Honor.
Thank you.
Is it your decision not to have a pretrial immunity hearing?
After consultation with my counsel, yes, Your Honor.
Okay. Has anyone promised you anything to get you to make this decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is your decision freely and voluntarily and knowingly made?
Yes, Your Honor.
Okay, thank you very much.
Thank you.
Thank you, Your Honor.
Okay. Did that take care of the matters that the state had set forth in their motion?
At this time, yes, Your Honor, thank you.
Motion, which motion do you want to have heard? The state has another motion that's not shouldn't be a lengthy one, and it's the state's motion objecting to release of...
Yes, they did. Maybe they can address that. You want to?
Your Honor, I would suggest that we have that after the motion regarding Mr. Crump because it deals with disclosure as part of that motion. I will be glad to address it now, but it deals with an issue that was disclosed as part of the response by defense counsel to Mr. Crump's motion. I can address it now.
It's in defense motion, it's not in Mr. Crump's
I'll be
motion.
glad.
And is that regarding an exhibit to the motion?
Yes, Your Honor.
Yes.
I can address it now if the court wants. I'll be glad to, but I'm just saying.
Okay. Is there
And we'll
any objection
confess.
to redacting that information?
None whatsoever, Your Honor.
Okay, I will give this to the clerk, and I believe if counsel will approach, and I agree that this is the information. the state's motion by redacting that information. Is there anything further on that motion?
John, just one final thing regarding our request that also that we redacted from any GZ legal document or website where that has been published to the public.
Okay, is that
Yes, sir.
agreeable? Thank
It
you.
is, Your Honor.
All right, then which motion do you want to file?
Well, as we were just speaking about Mr. Crump, and we have several pleadings that address the issue of, I guess it began with my motion to, in effect, unseal information identified as potentially being confidential. This is the subject being information
intertwined.
regarding the, I'm sorry?
They're all intertwined.
Yes.
Yeah.
Those three are all dealing with the fact that the Martin family accomplished a settlement against the Retreat Fee Circle Homeowners Association and the amount of it and other information regarding it. I don't want to belabor what I know you've read in the both motion response and memorandum of law, but basically it's a question of whether or not that private confidentiality agreement should usurp my client's rights to confrontation of that witness.
I was going to offer a suggestion, and if it is not acceptable by both sides, I'll hear argument. Would you like to hear that suggestion?
Certainly.
Okay, my suggestion would be that the redacted copy will remain sealed until further order of the court. An unredacted copy will be provided to both the defense and the state, and that will be provided by the confidentiality rules in this case. The redacted copy will be unsealed, and any issues as to the admissibility at trial will be determined at trial. Is that acceptable to the defense?
If I might have a moment, it sounds to be a good result, but if I might.
See if it's acceptable to the state.
Acceptable to the defense, Your Honor, yes.
Is it acceptable to the state?
I have no objection to that. It is,
Okay.
Of course,
there's
Mr.
other parties.
I just want to
Mr. Crump?
Mr. Crump the opportunity because he is somewhat of a party in interest.
I believe it goes beyond Mr. Crump. I
Well-
believe there's also other parties that,
Whoever may want,
Parties in the courtroom that feel that that is not a fair resolution to this matter.
one moment, Your Honor.
Yes.
Your Honor, if I may.
Yes, you may, Mr. Crump.
Very limited. We would only ask, as a state counsel and confidential parties, that the matter be kept completely under seal by the state and the defense, the unredacted version.
They're under an order issued by a prior judge in this case as to the confidentiality of any discovery, and that's what the court would order. Does that suffice?
Yes, ma'am, Your
And that
Honor.
would be until any further order of the court, because this issue may come up again at trial.
Thank you, Your Honor.
Is that okay?
Yes, Your Honor.
Okay. So with that, in regard to any and all the motions relating to the unsealing of the information listed as confidential within the court filing, i.e. the settlement agreement, the court orders as follows. The unredacted copy will remain sealed until further order of the court. An unredacted copy will be provided to the state and defense pursuant to this case's confidentiality order. A redacted copy shall be unsealed. Any issues as to the admissibility at trial will be determined at trial. You want to prepare an order that states that? Or?
I will do so. And I know the intent, I want to make sure we get it right. There was an unredacted copy was filed or given to you, Your Honor?
I have not seen.
Okay. I know the intent was to file a somewhat redacted copy.
The only way that I know that there is an unredacted and redacted copy filed under seal is per your motion.
Yes, Your Honor.
Okay.
I know the spirit of it, and we'll work up an order, get it past the state and Mr. Crump.
Okay, thank you. So then that leaves two more motions, and both of them are dealing with sanctions. Which one do you want to take up first?
Well, I think first, Your Honor, we would need to address my reply filed recently to the state's response, because inherent within my reply is a request to strike.
Is that the reply that was filed yesterday?
No, Your Honor. That response filed yesterday was responded to Mr. Crump's filing that I received in the afternoon hours of Friday, which is why the response violated your court order, but was within your spirit of the order to respond within 24 hours. But what is before you, Your Honor, is entitled Reply to State's Response to Defendant's Motion for Sanctions. And that was dated on April 26th.
Now, is this a response to the motion for sanctions for the video depositions or other sanctions?
Actually, for the other sanctions, Your Honor. The video sanctions stand by itself. So what you should have before you is my initial motion for sanctions.
Yes.
And that was, again, outlining, to be generic, the discovery issues that I have brought before you before.
I have that. I have the state's response and your reply to the response.
So I would ask that we address my reply first, and the reason why is within that pleading is a request that this court strike the state's motion as being, as I say, without responding in kind, unless the court actually would ever consider such an inquiry, that I believe it to be unethical and inappropriate and scurrilous and all those other words that I think are inherent within the state's response. So as basis of that, not only do we have the case law that I cited in my reply where counsel has been in front of circuit courts and have been sanctioned for filing such pleadings. Remind the court also of something that I know you're well aware of because I remember when it happened 18 months ago, Marion versus Orlando Payne Medical, when Jerry Jeffrey was before this court. You dismissed one of the counts. So Jeffrey, unamused with your decision, appealed it to the Fifth. The Fifth followed you, and Mr. Jeffrey, still not accepting the rulings of the court, filed a pleading, quite honestly, much less aggressive and inappropriate than what Mr. Delorianda filed. And of course, our very own Fifth had him before him on a rule to show cause and fined him for having filed a motion. And I know that you're aware of it because you were the judge handling it. My concern is this, and I take to heart, I truly do, what you said at the beginning of the hearing. All I can say is that this is obviously a very intense case. His response was a horrific attack on me, on my reputation before this court and in the public for doing what I'm supposed to do to represent Mr. Zimmerman. Why he felt the need to file in open court a pleading, and I know that you've read it, so I'm not going to recount all of the insults and the attacks and the innuendo and the downright lack of respect. In a case like this, one would think that we would be showing our best. And as I mentioned in my reply, this is where people are going to think the criminal justice system works or not. We're going to have a verdict in this case, and that verdict has to be believed by everybody who hears about it, good or bad, for us or for them. If we don't have the respect of now the nation or the world listening to what we do here, then the system loses respect. If anyone reads that motion in and of itself, they lose respect, not only for Mr. Delorianda, as well they should, but they lose respect for the system, and they're going to lose respect for the case, and they'll have yet another reason to disbelieve that we acted appropriately when we came up with the verdict in this case. I'm not trying to jump up on a soapbox and stay out of the sandbox. The reality is that that was a completely unnecessary pleading, offered nothing to resolution of the issues in the case, and I'm asking that the court strike it so that it is not part of the record that people are going to be able to read whenever they read about State versus Zimmerman.
Okay, thank you. Response?
Your Honor, we would object, and I'm not going to get into a banter back and forth referring to sandboxes or whatever else he was referring to. The motion speaks for itself. It addresses issues that were brought up by Mr. O'Mara on behalf of his client, specifically the conduct on his part and the process, which I'm appalled occurred when he didn't have the decency when talking to an attorney to tell him what was happening as opposed to just blindside him, which is fine, that's their right. But it talks about stuff that Mr. O'Mara has done, so that there's a complete record in terms of what has occurred in this case through the discovery process, in terms of passport, et cetera. And so it's a complete record of what has occurred in this case. I would submit not a complete record, but at least certain parts to establish the whole context of which it is said. We did not ask for sanctions when that occurred. You know, the state spent a lot of money investigating the issue about whether there was a false passport or not. Also about whether Mr. Zimmerman's wife had lied regarding that. That took a lot of time when there was acknowledged at some part, if you believe Mr. Zimmerman's conversation with his wife, that Mr. O'Mara was aware of it. Now, we're not asking for sanctions that, but I just want to make sure that the record is complete in terms of what occurred here. And so we would object to any striking of the motion. And by the way, this motion, the reply I got that at 9 o'clock, or I think exactly at 9 o'clock or 8:35 on Friday, which met the court's criteria in terms of 48 hours, but it didn't really give us a lot of time to respond to his reply, if we're being fair here and we're being professional, as Mr. O'Mara states.
Response? Any response?
I think the motion speaks for itself in my response and certainly my argument. Thank you.
I do, in reading the state's response, I do find things that this court wishes were not in a pleading, in a court file, and because of the recent activity from both sides, is why the court handed out the professionalism, because it will not be tolerated in the future. If there are some points in the state's response that do set forth a response to your motion. If there are certain parts that you would like redacted, I will consider that.
Thank you, Your Honor. To take the time to go through it paragraph by paragraph, here's what I would ask. That you do strike it, and I know you're not arguing what you just decided, that you strike it and give Mr. De La Rionda 15 days, 10 days, whatever he needs, to file a pleading that solely addresses the relevant issues before the court. In that way, I don't have to convince you that when he says, and you know, that,
I don't want
you know
to
what I'm
go
saying?
into what
I
it
don't
says,
want, right.
but if I were to go back to all the pleadings filed in the case, I could redact certain things
Sure.
from both sides. And I don't want to get into the habit of requiring parties to replead, not knowing what it is that is actually found offensive.
Agreed.
So if there are portions that you feel, I mean, it's
Yes, Your
been
Honor.
filed, it's been out
Sure.
there.
Okay, then
If there are
first-
portions that you feel that need to be redacted, or you're requesting specifically be redacted.
Yes, Your Honor.
If you could provide them to Mr. De La Rionda within 5 days, and he can, and a copy to the court, and provide a response to the court, Mr. De La Rionda, 5 days after you've received the defense, and I will go ahead and make a decision about redacting.
Fine, thank you.
Okay? So that takes care of that part of it. So now we get into the sanctions, and these are discovery violations, non-video depositions. So basically what I'm doing is conducting a Richardson hearing. And that requires for me to determine, was there in fact a discovery violation? Was the defense prejudiced by a violation, and what sanctions might avert any prejudice?
That's correct.
You may proceed.
I, at that point then, think it best to call Mr. West as a witness to this issue.
Is it going to be lengthy? Because I could have him in the witness stand or at the podium.
It's going to take a little bit of time.
Okay, Mr. West, if you'll come up to the witness stand, raise your right hand to be sworn. You may
If I
proceed.
might. Morning, sir. State your name, please.
My name is Donald Robert West.
And your occupation.
I'm an attorney licensed to practice in Florida.
How long have you practiced in Florida?
32 years.
And do you have an area of practice that you specialize in?
Yes.
Okay. Have you done that for the entire 32 years?
Yes.
Do you carry any certifications suggesting that you have or act as a specialist in the area of criminal law?
I do. I was awarded board certification by the Florida Bar in 1987.
Have you had that continuously since?
Yes, I have.
And you've obviously been involved as co-counsel in this case, correct?
That's right, since early June of 2012.
And during that time that you've assisted and co-counsel with me representing Mrs. Zimmerman, have you been involved in the ongoing discovery processes that we've undertaken?
I have.
And going particularly to the motion that is pending before the court, which is the motion for sanctions against the state for discovery violations. Are you aware of the representations made in that motion?
Yes.
Are you similarly aware of the basis that led to filing of that motion?
I believe so.
I would like, if you would, to recount testimony that you would have regarding what is known as the witness 8 issue, and when you first became aware of it, pursuant to discovery, and our response to first becoming aware of that information.
As I remember, there was a CD recording provided in discovery sometime, I think, in June, perhaps in May, but I wasn't in the case yet. That was a recording provided in discovery that was an interview conducted of witness 8 by attorney Benjamin Crump, believed to be on or about March 19th. There wasn't any accompanying information with that. It was simply the CD that was of very poor quality. Also, in the early discovery was another recording of an interview conducted by Mr. Della Rionda on April 2nd, 2012. Again, I don't think there were any other reports other than perhaps a brief memo that was prepared by Mr. Osteen, Mr. Della Rionda's investigator, outlining that the event took place, that the interview took place in Miami at Ms. Sabrina Fulton's residence. The memo, as well as the recording, identified some of the persons present, as it turned out. They identified a couple of representatives of FDLE and Mr. Osteen, I believe.
Let's speak then for a moment to the first CD that was received. Was that CD complete, or was it redacted in any form or fashion?
It was redacted of identifying information of the witness. It was a little hard to know what else may have been edited because it was a CD of a continuous conversation, but it was evident that the recording itself had either been stopped and started or edited in some fashion. It wasn't one conversation that took place over the length of the recording.
As to the information that you say was redacted, you're aware of an order entered by the court to redact from some discovery certain witness identifying information, such as a name and even an address, correct?
Yes, that's right.
That was redacted at the very least from this CD that we received. Is that also correct?
Yes, but there are two CDs. The interview that Mr. Della Rionda conducted was also redacted.
Let's speak to the one of the interview with Mr. Crump. And I'm going to ask you then to fast forward for the sake of both brevity and to close the loop. At some point in this discovery process, did we identify that there was additional information redacted from that first CD?
That's hard to answer because obviously the identifying information was redacted. After several requests and some motions and some hearings, finally we got another copy of that recording, and that was unredacted. And that was represented to have come from Mr. Crump's own digital recorder. It was represented to be complete. And when you say redacted, I'm not sure, because then after that, just recently, in fact, we learned there was yet another recording of part of that conversation that was not included in either of the recordings that we had received. Yet we could figure out where it fit. So clearly that had been redacted or not recorded along the way.
And that was what we can term for today's testimony the ABC recording edition?
Yes, that's right.
Going back now for a moment to the April 2nd interview of Mr. Della Rionda that he took with this witness aide. What information was redacted from that CD?
The name, of course. I don't remember specifically an address being offered. The birth date of the witness, which was later to be important to me as I was trying to sort this out. Also redacted was the name of the school that the witness attended, and as I recall, also the name or names of individuals that she identified as being friends of Trayvon Martin.
In reviewing the order requiring redaction of certain identifying information of the witness, such that certain redaction would be appropriate in this tape, was there information redacted that was not appropriate to be redacted?
I had been told by Mr. Della Rionda when I requested unredacted copies of all of the witness interviews, including this one, that the only information that had been redacted was personal identifying information, name and address, and I suppose phone number. It turned out when we examined the recording of another witness, we found that wasn't accurate. And we, in fact, found 10 or 20 seconds that had been edited. So that became an issue and revealed to me, and in my conversations with you, that there seemed to be something going on here. So we started making some requests, focusing first on that other witness. And then there were a number of requests, more informal, and then ultimately some written requests for copies of these unredacted interviews. And from a timeline standpoint, the information was available to the state at the very beginning of the case. It was part of the initial round of interviews by FDLE or by Mr. Della Rionda and his staff. We didn't get those recordings unredacted until sometime in late September 2012, where then we had available for the first time the opportunity to compare the redacted recordings with the unredacted ones. I have a bottle of water there. May I have that?
If I might, Your Honor.
Yes, you may.
Thank you.
You had also mentioned that there was a report generated by a state attorney's office investigator regarding the April 2nd occurrence. Is that correct?
Yes.
And what information, firstly, what information was on that report? And then I'm going to ask you what information have you now found out was left off?
I don't have full recall of what was on it. I think it's readily available. I may have it with me, although I'm not sure, but I can summarize it certainly from memory. The report documented the occurrence. It indicated that the interview took place with the witness. As I recall, it identified that the interview was at Ms. Fulton's home. It identified that Mr. Della Rionda conducted the interview, that there were other law enforcement representatives present. I believe it also indicated that attorneys for the Martin family, I think perhaps identifying Mr. Parks and Mr. Crump as having been present at some point. And identified that there was a conversation with the witness just by, I think it said just preliminary. And as I recall, that's the primary substance of it.
From now having taken that witness's deposition and additional discovery efforts that we've had to undertake, what have you found that was not included either in the taped statement itself, the CD, or the report regarding it?
Well, as recently as last week, I learned that Mr. De La Rionda went to pick up the witness at another location to bring her back to the home, and that Mr. Crump was also involved in one or the other cars. I learned last month when you and I were in deposition of this witness that the interview took place in Ms. Fulton's living room, and that Ms. Jackson was present during the interview, and that Mr. Martin was present in the home, although I don't believe present in the interview as well. And other family members were around. I believe the witness said Mr. Crump had left at the point the interview actually began. But what really caught my attention was that the witness testified that during the interview by Mr. De La Rionda, Ms. Fulton was seated directly next to her. That caught my attention because that seemed inconsistent with what I would have thought an interview by a recently revealed witness portrayed, at least by some, to the most significant.
What is the relevance?
As to our finding out only recently that Mr. De La Rionda...
What his thoughts are, or what it would betray, portray?
Well, because it is our job to find out whether or not witnesses have an improper...
Not the finding out, it's what this witness's opinion is as to what it would portray.
Maybe then I'll...
Finding out the information, it is the witness's personal opinion on what it would portray.
Okay. It sounds as though you've made your ruling, so I'll move on.
Well, I'm asking you, what is the relevance of this witness's personal opinion?
It led to the additional work that we had to do because of the way the interview was handled. We're here on sanctions against the state for the way they handled the discovery and didn't give it to us.
Then there is no ruling. The ruling would be that his personal opinion, but what actions he had to take upon learning this information is relevant.
Are we focusing then? Sorry.
Thank
you, Your Honor. Any additional information besides what you've just mentioned, just to finish up this inquiry portion, about what was not disclosed either in the CD, having been redacted, or in the report created by Mr. De La Rionda's office?
The witness said that she had lied about saying she'd gone to the hospital. And she confirmed that she had repeated that in the interview with Mr. De La Rionda. She seemed uncomfortable, and she said that Ms. Fulton was crying during the time that she was being interviewed by Mr. De La Rionda. I believe that I am experienced and trained to get a sense through an investigative perspective what certain things mean to me that might direct a further inquiry. And that really caught my attention.
Now, to move forward, and we may come back to points in between, but to move forward, was there a time that this witness, witness 8, had yet additional conversation with Mr. De La Rionda that at some point was disclosed?
Yes.
And what was that?
The timing on that is, as I understand it, this. By just a bit of context, we had filed motions seeking for additional discovery, including reports from FDLE and the FBI that we believed, after talking about it, must exist. The record seemed to be incomplete, notwithstanding the state's protestations that everything had been provided. We had a motion to compel in this court in October. I believe it was mid to late October, where an attorney for the state stood up specifically and told this court, we have given the defense everything. About 10, 12 days later, we received by a supplemental discovery disclosure, I believe it was number 9, 10 additional FBI reports, and I think it was 35 additional FDLE reports. Also referenced in those reports was additional information that, in my opinion, was discoverable, but had not yet been provided either. Contained within that grouping of 35 or so FDLE reports was a memo written by an agent from Miami that had escorted this witness, witness 8, to the airport, put her on a plane to Jacksonville about August 2nd. That there was also another short memo that a couple of days later, FDLE met her at the airport and returned her home, I guess. So I learned from that discovery in November that the event on August 2nd, August 3rd had happened, reflecting a personal meeting with this witness and representatives from the state attorney's office.
Up until that point, had anything been disclosed regarding that interview between Mr. Delarianda and witness 8?
No, no idea.
Okay. Then at some point, did we find out information regarding that meeting?
We found out during this witness's deposition in March. I
Not
believe,
before?
I think it was March 13th or 14th was the first time that we learned that she had told Mr. Delarianda in August that she had lied about saying earlier she'd gone to the hospital.
And did she identify that that statement occurred during the interview that Mr. Delarianda had with her in Jacksonville on August 2nd?
That's right, she did.
Until March 13th, had we been given any discovery, any information which would document that witness 8 had lied about the hospital visit?
Yes, I think so, because you and I had talked about it just there being something that didn't quite fit. And then we got the memo about the trip to Jacksonville. I did research online to see if I could connect up this idea of the hospital. There were statements by witnesses that said that she had said she'd gone to the hospital. Other people said she'd gone to the wake or the funeral. I thought that would be a significant fact, something that could be proven easily one way or another, so I began a series of communications with the state to try to determine that. More specifically to your point, though, we had a hearing scheduled in this court in early March, as I recall, because we decided we're not getting any information. The letters, emails are unresponded. We learned there was a meeting, so we sought a subpoena, Ducas Tecum, a subpoena to produce hospital records directed to that witness. And apparently on the eve of that hearing, which I believe was scheduled for March 5th, so it would have been probably on March 4th, if I've got the dates right, you received a call from the state attorney's office suggesting that, in fact, there will be no records because they knew that the witness had lied, effectively. And I guess you were the party to that conversation. I wasn't, although I was told about it. The next day, when we were in court, I asked this court to inquire of the state when they knew that. When did they know that witness 8 had lied about going to the hospital? The court, not being fully apprised of all of these issues, declined to make the state answer that question. It turns out that when we took the witness's deposition, she clearly stated under oath and then confirmed it again that she had provided that information in August.
Further in the motion filed, we had given the court additional background on other concerns as a foundation for the sanctions in this particular matter. And before we get to those, if you could summarize the time that it cost you and us, Mr. Zimmerman, to track down the information not properly given to us by the state, in your opinion, and recount that for the court.
Thinking back on the history of it, it started with identifying several issues informally, phone call, conversation, that led to emails. I know that we were very frustrated when we learned about the telephone, that there had been a report prepared on it that we had never received. We were very frustrated that we were not getting original or good quality copies of photographs, of reports. It's almost as if we weren't getting the information until, loosely said, until we caught it being hid. And then we were starting to get it. So there were photographs, the original photographs of Mr. Zimmerman's face after he had been punched in the nose and bleeding, the back of his head that showed the blood. The list is pretty long, but I memorialized some of that in emails and then a letter. And part of the time, the frustration and an enormous amount of time was spent trying to figure out what we believe existed that we weren't getting. We were mostly right, as it turned out, but it took an enormous amount of time just to figure that out so we knew specifically what to ask for, because otherwise we weren't getting it. The explanation was, oh, I don't know, I don't remember that. I asked Mr. De La Rionda, could we have a copy of Trayvon Martin's school records if you have them? I don't know. I don't know if I have them or not. To me, that just didn't ring true. I can't imagine he wouldn't know if he had them or not.
Was this at a time where he had already gathered Mr. Zimmerman's school records at the same time, or previous?
That was all those were ongoing issues. That's why I asked for this witness's hospital records. I knew that they would get them. I can't imagine they wouldn't have gotten them because she said I was in the hospital. They would want to corroborate that. So I said, if you've got the records, please give them to me. We will maintain their confidence. I said that in writing twice, orally a couple of times. No response. No response like, yes, we'll give them to you, no, we don't have them, or you're on your own. Just no response. To put a number on it, I don't know, 50, 100 hours, and that would be conservative, I would suspect. And we're not done yet. That's part of it, too. We're not done.
Now, you know, as part of this motion, we have limited our request for attorney's fees, you for 4 hours, me for 4 hours for the work done in this case. Would you consider that estimate accurate, low, high for the time that was spent?
I think that's low just on the issue of the hospital records alone, much less all the stuff that's wrapped up in it. That's a drop in the bucket, probably.
The underlying motion addresses several of the issues and includes certain exhibits. Do you have those exhibits available to you? They are identified for the court's purposes as defendant's motion for sanctions against the state, filed, Your Honor, on March 25th, and the exhibits attached to that ones to focus on for right now are exhibits E, Your Honor, and F. Mr. West, do you have it available? If not, I might ask you to approach the witness.
I have a copy of the motion here, and believe it has the exhibits. I'm sorry, identify it again, please.
Letter E, as in Edward.
Yes, I have that here.
Okay. And could you identify for the court what that is in relation particularly to the sanctions sought today for the witness 8 disclosures or failure to disclose?
I had mentioned earlier that not getting a response to conversation specifically or less formal approaches, the next step was to memorialize it in writing. Exhibit E is an email I drafted after talking with you about some of our issues regarding discovery, dated August 23rd.
How many days after the interview that Mr. Delarianda had, where he first was told that witness 8 had lied about the hospital visit?
Well, just by doing the math, it looks like about 20.
Did you get any response to that email?
No. It was sent out the day before a hearing, as I remember. We had something on the 24th that brought us to the courthouse because I remember after whatever that was, we met together to discuss discovery issues.
Did we even in that meeting also discuss the issue concerning the hospital records?
I think so. I had the email. Mr. Delarianda acknowledged having received it. So we had a whole list of things. It's Exhibit E.
Did Mr. Delarianda, at the meeting that we had after the hearing on the 24th or 5th, did he tell us at that point that he then knew that there were no hospital records to find?
No.
Did you then follow up that request with an additional letter between that email and the next correspondence, which is Exhibit F? Were there additional communications, either with you or that you're aware of with me, with the state attempting to get those records?
I don't remember specifically speaking with Mr. Delarianda during that time. I know you and I talked because there was no response. We waited a week, 2, no response, and then decided to try again in writing, and that then was the basis. Some things had happened during that time. Some, I believe, discovery may have come in. There had been additional information gathering, but there remained significant discovery issues between the 23rd and then when I memorialized it in some correspondence dated September 19th.
And does this, again, the September 19th letter, further your or our request for the information concerning hospital records? Similarly, as we're on F, does it also reference our ongoing attempt to get the digital file concerning Mr. Zimmerman's facial injuries? I would focus you on the second page of your letter, paragraph 4.
The digital images were taken from a cell phone. We knew that. But we had never received them. And there had been repeated requests, including here. And as counsel in the court may remember, we actually filed a motion to compel production of those. And we had a hearing. And finally, the court ordered the state to produce those. And eventually we got them.
And pursuant to previous motions that the court is aware of, we had first received a black and white color and then a color copy or color, and only after the court order was entered did we receive the digital copy?
Yes, that's right.
After then, sort of moving forward from that timeline, what information did we finally receive from witness 8 during her deposition, which identified that there was information not forwarded by the state in a timely fashion.
I'm not sure I fully understand the question. To the extent I do, the witness confirmed that she had not been to the hospital, and she confirmed that she had told the state that she had not gone to the hospital as early as that meeting in August. She also told us who was in the room with her during the interview, and at Ms. Fulton's house, and more fully developed some of the issues that we were trying to find out information about. Sure.
Did she also disclose then that there was a writing or memorialization concerning an initial communication with Ms. Fulton that had not been disclosed?
Well, she wouldn't have known it wasn't disclosed. What she said was that she wrote a letter with the assistance of a friend that she planned to give to Ms. Fulton, in which she then said she did, that she wrote it with the assistance of her friend about March 19th, 2012. That caught my attention as well. Because that was the same day of her interview with Mr. Crump. She did not have a copy of it, but she explained to us that there for the first time, basically, she outlined the information that she had about the events of February 26th.
And was it further at a later date that we identified a witness who helped her in writing that letter?
Yes, when we talked to her about her trip to Jacksonville, she told us, for the first time that we knew about it, that she had been escorted there by a friend. She didn't know the friend's name, but she told us her first name, Francine, I believe. And
Your Honor, I'm going to object. We've taken great steps to, and that's why I filed my motion.
Agreed. It should be redacted, and Mr. West, I know that we're both very cautious about even first names. But, let's
Very
just
well.
use more generic
Apologize.
terms.
she was escorted there by an individual and at the state's expense. And then she identified the person later at the deposition that had helped her write this letter.
And did we then find out that it was actually a different iteration of that letter, or that it was done in a different form or fashion?
Yes, yes.
Nothing further, Your Honor.
Proceed, Your Honor. Let's talk, let's go backwards if we could, at least for the purpose of that letter. Isn't it true that that letter you spoke of, that that witness assisted or wrote for witness number 8 was actually provided to you by, in fact, the original one by Ms. Fulton? You recall in the deposition Ms. Fulton saying that she had it, she hadn't told anybody, and that she actually brought it to the deposition, in fact, took it out of a Bible and said, this is my personal property, and I did not want anybody to do it. In fact, we made a copy of it, and you all agreed on the record in that deposition that she could keep the original. Do you recall that?
I'm sorry, you've asked me 4 or 5 questions.
Well, I'll make it simple for you, sir. Isn't it true that the state did not withhold that letter you spoke of from you until we found out all about it together?
I can't speak to when you found out about it. You are correct that when the witness identified the letter, the next day, Ms. Fulton brought the original with her. and you told me that you had not had it before.
Okay.
Yes.
And was there any evidence that the state had it before that day?
I don't know, because I asked you, when did you know about it, and you refused to answer that question.
Sir, what did Ms. Fulton state under oath in that 7 hours, I think it was, deposition where you asked her extensively about all kinds of stuff?
Regarding the letter?
Yes, sir. What did she say about the letter, sir, under oath?
She said that witness 8 gave her the letter,
Okay.
and that
What did she say she did with the letter?
she said that she put it in a place where she had been keeping other correspondence or notes of condolence.
Right. And do you recall that, in fact, at that deposition, she brought the original letter in her Bible to that deposition? She sat there and showed you the original letter.
Yes.
And isn't it true that Sabrina Fulton's deposition was taken after witness number 8's first deposition was taken?
Yeah, the next day.
And isn't it true that witness number 8 did not mention anything about a letter in that first deposition?
No, I think that's incorrect.
You believe she stated that she had written a letter and that she still had it and that she gave it to the state?
I'm sorry, that's 3 or 4 questions again.
Okay, I will try to make it simple,
Here's what
sir.
she said.
And the reason I asked you, sir, I apologize, I don't mean to argue with you, but Mr. Romero asked you compound questions. I will try to make them one sentence at a time so you can follow. Isn't it true, sir, that witness number 8 mentioned a letter and she stated that she had not given that letter to anybody other than Ms. Fulton?
Witness 8 testified the day before Ms. Fulton's deposition that she had, with the assistance of a friend, prepared a letter.
Did she say she gave it to Ms. Fulton, is my question, sir?
Yes.
Okay.
Yes.
Did she say she had mentioned it to the state prior to mentioning it in the deposition?
She did not say that.
Okay. So when you were asked by Mr. O'Mara a big deal about this letter, isn't it true that, to your knowledge, the state was not aware of that letter other than when she mentioned it at a deposition, when witness number 8 mentioned the deposition?
I asked you about it, and you didn't answer, and I have no other information one way or another.
If you could, with all due respect, sir, answer my question. Any knowledge that you have that the state of Florida had knowledge of that letter prior to her deposition, the witness number 8 mentioned a deposition in front of all of us?
You never mentioned the letter. That's true.
So is your answer no, you did, there's no knowledge? Can you just answer yes or no, please?
I don't have any knowledge of you knowing about the letter.
Okay. Did the witness state that she had given the state that letter prior to the deposition where she was asked about it?
No, she didn't.
Okay. Did she say she had given that letter to Ms. Fulton?
She did.
Okay. And when Ms. Fulton came in, did she bring the letter in to the deposition?
Yes.
And did Ms. Fulton not state that she felt that was a personal letter to her, and she in fact had not told anybody about it other than in terms of the deposition when she brought it in?
Object, Your Honor. That question was asked and answered precisely in the same way.
Isn't it true, sir?
I'm sorry, I didn't follow the question.
Madam Court Reporter, would you mind repeating the question, please?
And did Ms. Fulton not state that she felt that it was a personal letter to her, and she had in fact had not told anybody about it other than in terms of the deposition when she brought it in?
Ms. Fulton testified that she did not share the letter with anyone.
Okay. So the allegation that you and I respectfully say the defense counsel has been prejudiced in some way because the state did not disclose this letter, isn't it true that that's a false statement in terms of an allegation the state did something improper?
I don't remember that allegation, I'm sorry.
So why did we spend 5 minutes being asked about that allegation if it's irrelevant to this motion before the court?
I'm sorry, I don't know what you're asking me. Are you saying, why did Mr. O'Mara ask me
Yeah,
questions
and
about the letter?
why did you interrupt him and say, Mr. O'Mara, I'm an attorney, that's irrelevant to this thing, why do we need to bring that up to the court?
Sorry, if you thought it was irrelevant, I assume you would have made the objection.
Why did we bring it up in front of the court? What's the relevance of that?
We object on this point, argumentative.
Sustained.
Don't you agree that that's irrelevant to your
Honor, I
motion?
thought you sustained my objection, did you not?
I think he's trying to ask a new question. Wait till after the question.
Yes, Your Honor.
Don't you agree that that's irrelevant to the motion?
Your Honor, same objection.
The court will make its own finding. Thank you.
Now, there's been a lot of things brought out, so let me start at the very beginning, if we could, of Mr. O'Mara's questioning of you. Isn't it true that the defense believed, based on the conservative treehouse and other areas out there, other Twitter, other stuff, that there was this girl, and she was really 16 years old, and you all, or these groups, thought that they had identified who witness number 8 was? Do you recall that?
I recall there being internet activity about who this witness was. I know that there had been public statements made by people who claimed to know her age, that she was 16.
And
I knew that.
Yes, sir. And do you recall, in fact, Mr. O'Mara, now this, quite frankly, may have been prior to you getting the case, in open court saying, oh, we know who this witness is, and there's information about her out there. Do you recall Mr. O'Mara making those statements about witness number 8?
I don't for sure.
Okay.
I don't know if he did or not.
But you do recall that apparently these conservative treehouse and other groups had actually, pardon my language, I don't know what the word is, doxed or whatever, actually singled out a lady, a girl, quite frankly, who turned out not to be witness number 8.
Could I speak to that?
Could you answer my question, sir? Do you recall that being out there?
I remember there being internet activity where bloggers thought they knew who this person was, yes.
And do you recall, in fact, and I commend you, Mr. O'Mara, and you, do you recall that you, in fact, and the GZ Legal issued a bulletin, I guess you would call it, stating that this witness was doxed or identified, and that people need to stop doing that?
Well, I was around for that. That wasn't all that long ago, actually.
Do you recall that being done?
That's it. That, keep in mind, I don't have any direct participation in posting.
Who does that?
In the sense that I don't know how to do that.
Okay.
I'm sorry.
Do you read that after the fact, or do you approve it, or is it just done without you and Mr. O'Mara's approval? Do people just post that? When I'm talking about GZ Legal, is that done with your all's approval? Do you look at each one of those postings to make sure it's accurate?
Well, I think generally that's the practice, sure.
Okay.
As to the doxing comment, I think you're referring to concern about people being essentially harassed.
Yes, sir.
By virtue of people, frankly, unrelated to us, trying to identify people or trying to release information that might be considered private.
When you state unrelated to you, are you stating to this court that you have not adapted or incorporated any of the arguments made by the conservative treehouse in presentations to this court?
I don't know what you're asking me. Are you saying have some of the legal issues that have been raised in this court been discussed at some time on the conservative treehouse? I think that's possible, if not likely. But are you asking me if that's where I get my ideas? Or that you're saying that Mr. O'Mara gets his legal strategy from people on the internet? I challenge that.
Yes, sir. I'm not going to argue with you about that issue. It speaks for itself. My point is...
It doesn't speak for itself.
Wait for a question, please.
Certainly.
My point is, would you not agree, sir, that both sides have attempted as best as possible to conceal the identity of certain witnesses?
Yes, there has been a sensitivity to that.
Yes, sir. Including go into the steps of, in certain cases, not revealing the addresses of those witnesses.
Sure.
Okay, including, for instance, the defendant's family, brother, and the defendant himself.
Yes.
In fact, in the depositions that I took of them, I specifically made a point not to ask them their addresses. Do you recall that?
That was your decision.
Yes, sir. Do you recall that?
Sure.
Okay. Do you recall that you did ask Ms. Fulton, Tracy Martin, the brother, all the family members of the victims, their addresses?
That's right, I did.
Okay.
Well, I didn't personally because I didn't interview everybody, but
You or Mr. O'Mara?
yes.
That wasn't a trick question. Do you recall asking them that information?
Yes. Uh-huh.
Okay. And during the process of discovery, is it possible that inadvertently sometimes information is disclosed,
Yes.
such as was done in this case?
I did it today.
Okay. Would you agree that happens?
It did.
Okay. And would you agree that that's inadvertent?
It was today.
Right? Would you agree that was not intentional?
Yes, I apologize to the court.
No, sir. I'm just saying, do you agree that that happens as part of the discovery in every case, but in this case also?
Well, it can be inadvertent because that's happened, yes.
Okay.
And I agree with you. It's
Yes, sir.
unfortunate,
Now-
and it's not purposeful, is what you're suggesting.
Yes,
I
sir.
suppose.
Yes, sir.
Sure.
Do you agree that part of the discovery was pretty extensive with the state? Let's talk about the original state discovery. It included 8 pages, and it had attached to it numerous documents. Do you agree with that?
Yes.
And do you agree that as part of that, witness number 8 was identified by name in that discovery, not tendered in terms of in court, but to you all specifically?
Yes.
Her name was mentioned. Would you agree with that?
He was identified.
Okay.
Yes.
As was witness number 9. There was a bunch of witnesses, basically. Do you agree with that?
Yeah, there was a procedure put in place.
Okay. But my point is, for the record, you were aware of her name.
Yes.
Okay. And when you stated that the original CD that was given to you did not have her name, you were able to match. It said witness number 8, and her name is blank blank, right?
Uh-huh, sure.
Okay. I mean, you were able to match them up. Would you not agree? Who witness number 8 was and what her name was. You were able to match it up. You were able to connect the dots. Correct?
We knew the name of the person that had been identified as witness 8 from the discovery exhibits.
Okay.
Provided
And you-
to us, yes.
Yes, sir. I apologize. Is that accurate,
Uh-huh,
Mr.
yes.
West? And you agree that you were provided her statement that was provided to the state in terms of Mr. Crump, the recording, correct?
Well, that was almost impossible to hear, and there were conversations we had about getting a better copy, and that, as you know, played out, and we finally litigated it and got it sometime after the first of the year, I think.
But would you agree that the state gave you the exact copy that the state had? in
I have no
terms of
idea.
Mr. Crump?
I have no idea whether you
But
did or
may I
not.
still look at the one I got?
Are you asking me, did you give me a copy of what you had?
Yes, sir.
I don't have any reason to think otherwise.
Okay, thank you. And you agree that all this questions that you were asked about Mr. Crump and all that, that was because you all alleged that Mr. Crump had redacted something when in fact he had not. Would you agree with that?
No?
What evidence do you have, because you're making an accusation against another lawyer, that he redacted something from that recording?
Well, part of it depends on how you define redact.
Okay, well,
We
what is
know-
your definition of redact so that we make sure we're on the record in terms of whether you're making an accusation against a fellow lawyer who's in this courtroom that he redacted something?
Okay? May I think, as I'm answering this, about the recordings that we actually got at the end of the litigation stream, or should I only think about the CD that you gave us at the beginning? Because those are two very different pieces of evidence.
Do you agree that there was no redactions made by Mr. Crump regarding the CD that you got originally?
I don't know.
Okay, well, let's go back to your definition. What is your definition of redaction? To me, I'll tell you what my definition is. Make sure we're on the same page.
Part of the reason-
Redaction means that you take something out on purpose and you don't reveal it to the other side.
That's a fair
Okay?
definition, I
So
think.
what you're stating is that Mr. Crump got a CD, made a recording, and took out certain parts and only gave the state and you certain parts.
No, I'm not saying that.
Well, why did you make a statement that he redacted certain parts of that recording? When you were asked by Mr. O'Mara, why did you state under oath and direct that Mr. Crump had redacted stuff from that recording?
I didn't say that.
So I misunderstood what you said?
I think so. I'm happy to explain it.
Okay, so isn't it true what occurred, sir, is that you were requested and you filed a motion, when I say you or Mr. O'Mara, on behalf of Mr. Zimmerman, to ask that you get the original recording, and then Mr. Crump provided the actual recording device, and there was a CD made of that. Is that not true?
The general sequence of events, yes.
Okay. And what difference was there between the original CD or original CD that I gave you, the state gave you, I apologize, and the version from the recording device itself, other than perhaps clarity?
Well, that's true. Quality was a big issue.
Okay, so there was
The-
nothing excised that.
If I might,
Let him
would he
finish.
be
I
able to answer
apologize, I apologize,
Let him finish his
I
answer.
apologize.
Are you asking me what's
Yes.
different?
Yes,
What was
sir.
different? The CD that we got was, it seemed to me, to be a second or third generation recording, as if it were made by recording through a speaker. Like the original recording was played and it was recorded just through a speaker into a microphone. So the quality was really bad. And then that the disc, as I remember, was somewhat continuous. Each section played on to the next one. They were not discretely identified as separate pieces of a conversation.
Yes, sir.
And then when you listened to it from beginning to end, it was evident that things were missing, that the conversation didn't flow, that it stopped and started. So it seemed clear to me that either something had been taken out or the recording device had been stopped and started so as not to record the entire conversation.
And would you agree that there's a difference in a statement being said that something is taken out as opposed to something starting and stopping? Correct?
If it depends on what your purpose is.
Well, my question,
If your purpose
sir,
is not to reveal the whole conversation, then it hardly matters. But if you're asking me, was it edited after the fact? Yes, I understand the distinction.
And there was no editing after the fact, is that true?
Well, then I have to fast forward to what we actually got after the court ordered Mr. Crump to produce the recording. What we got there was
Stop and start, right? There was like
Well,
8 different-
Would the witness be able to answer the question?
I apologize.
Thank you.
Go ahead.
What we got was, rather than a continuous conversation, is we got, I think it was seven separate audio files. One of them had virtually nothing on it. And that the beginning, that the end of one did not match up with the beginning of the next. So it was clear, in my amateur way, that the recording had stopped, something had transpired in the middle, and then the recording picked up again, and that happened several times.
It's my fault that I'm not asking the question, but my question specifically is, in a comparison of both, the substance of what was said. He said the house was green. The house was green also in the second thing. There was no change. The house wasn't taken out of that sentence. Correct?
No, I don't remember there being any substantive or any difference
Okay.
of the content, with one caveat. And that was that as we began to litigate this issue, there was an affidavit filed where Mr. Crump said there was no conversation during these spaces or these gaps, and that the reason that it appeared to be stopped and started was to give him an opportunity to think or to formulate the next question, and then when he was ready to record, then it would start.
I guess.
And the problem there is that when you talk about things being taken out or put in, as we referred in my direct, ABC was present in the room with its own recording device.
Yes, sir.
And,
Your Honor,
and
again, will you just be able to answer the
Yeah,
question?
Okay,
It
but
is
I think he's going into,
responsive.
we're going into a narrative.
But it's responsive to his question, and he needs to be able to complete the entirety of his thought. I don't want,
Mr. De La Ronda hasn't gone on to ABC, and this witness has, so he's beyond the question and going into a narrative. I will sustain a state objection. If you'll next ask your next question.
The bottom line, sir, is that there was no difference in terms of the substance of what was in Mr. Crump's original CD and the, other than, obviously, it's segments, there was no difference in the substance. Would you not agree?
here's what I...
My
what,
question
here,
is yes or no? Was there a
I
difference or not?
can't answer that yes or no, but I can say this. I could understand more of it with the better quality.
Okay, thank you, sir.
But I have no reason to think that the recording itself had been altered. We got it until the second.
Okay, I thank you for clarifying that. So the bottom line is regarding that issue, there was no difference.
I don't think so.
Okay, thank you.
Yes, you have to have a picture. Thank you, you may proceed.
Thank you, Your Honor. Let's move on to another subject because I'm trying to address all the allegations that were made. You mentioned ABC, and that's, do you remember who the reporter was? You're talking about that was present for the interview of witness number 8 by Mr. Crump and others? Is that who you're referring to?
I was, yes.
Do you remember who that reporter was, sir?
I do.
Okay.
So
who was
Mr. Matt Gutman.
Did the defense file a motion requesting from ABC those records?
You know, I can't remember if we filed a motion that was pending hearing. I think so. I think we filed a motion to try to get whatever they had.
Right, and I believe you're correct, and I asked that in a non-leading fashion to see if it would trigger your memory. What steps have you taken to bring ABC in here and to get those records?
Well, I know that counsel for ABC has been in contact with Mr. O'Mara.
And what happened between counsel and Mr. O'Mara? Was there some agreement that certain records would be disclosed to the defense without having to appear in court? And second of all, and that's a compound question, did you inform the state and the court of that?
I never had a conversation with counsel for ABC, so my information is secondhand at best, if not. It's my understanding that the position ABC took with let me back up just a little bit. We knew from phone records that the conversation with the witness, at least in terms of when the start and stop times were, the phone calls was the better part of a half hour, 25, 26 minutes. We also knew that when you added up all of the pieces of the interview, it was 12 or 13 or 14 minutes. I think less than half, maybe, of the whole conversation. So we knew immediately that the whole conversation wasn't recorded. We also knew, finally, we learned that a reporter for ABC was present in the room, which led us to think, well, maybe they would have recorded it themselves. We got no help from anybody on that. Not you, not Mr. Crump.
Okay, my question is, ABC specifically, did you all file a motion requesting that the court order ABC to turn whatever documents they had, whatever recording they had, to you all, to the defense? Did you not file a motion requesting that?
Yes, we did.
And that motion is still pending, I believe, correct?
I don't think it's ever been called up for hearing because of what happened.
Okay, and is what happened that you all had a conversation with ABC? When I say you all, I'm talking about Mr. O'Mara, yourself, or somebody else representing Mr. Zimmerman?
Yes,
Is that
that's,
true?
well, counsel for ABC, and I don't know who else necessarily, but it was represented to us that the only recording that ABC still retained was about 5.5 minutes.
And did
And-
you obtain that from ABC?
We were, I think Mr. O'Mara was talking with them about getting that.
Okay, and did you end up obtaining it from ABC?
No.
Either directly or indirectly, Mr. O'Mara, somebody else in the law firm? Did you all get it?
No, not from them.
And did ABC just say, well, we're going to disclose it, but we're going to put it on YouTube or something?
I heard it for the first time by playing it, I think it was from ABC's website. They posted it, a link to it, and that's when I listened to it for the first time.
And that was after conversations between Mr. O'Mara and somebody from ABC, an attorney or something?
During that same time frame.
Did you inform the state and the court of that?
Well, I think indirectly, we filed some motions about it.
No, I mean, once there
We
was
quoted
no...
from it.
Pardon me?
We filed some motions, we quoted from it, because the clip from ABC fit neatly in between two of the clips that we'd been previously provided, which suggested that, in fact, there were substantive conversations had that were denied as having occurred, that in fact existed, and we wanted to...
My question is that you informed the court that you had discussions with ABC and you got that information and ABC agreed to disclose it or whatever.
I don't think so.
You're required under the law to provide reciprocal discovery to the state, are you not?
Yes, under 3.220.
Was that ABC recording disclosed as reciprocal discovery?
Have we filed an exhibit identifying it?
Yes,
I
sir.
don't, no, I don't think so.
Do you know how many hours Mr. Guy spent researching that issue in terms of getting that? Should we file a motion for sanctions against you all for that?
I don't know how many hours he may have spent. It was readily available online, and it was cited, I think, if not provided, as part of a motion we filed.
Okay. You go to regarding discovery, and you mentioned that there was documents that were tendered to you all as part of discovery in the original discovery response, just to clarify, give you context.
Yes.
That had excised out the names of the witnesses, of certain witnesses. Is that correct? From the recording itself, from the CDs.
The recordings themselves had been edited, yes.
And then you ended up getting that CD that had their names on it, correct?
Eventually, we got it in late September.
Right. After you requested it, correct?
Yes.
Okay. And isn't it true that at some point there was a motion filed by the defense regarding witness number 9, and you alleged that you did not, even the recording, even though we gave you an extra copy, that the second copy was still not, didn't disclose her name, or didn't have information about what she had said? Do you recall that? The one that she's, witness number 9 is the one that made an allegation regarding the defendants doing something to her for purposes of reference in terms of who we're talking about, without revealing her name.
What's your point? What are you asking me?
My question is, do you recall making an allegation or a motion regarding that somehow the state had given former Judge Lester a different copy and you asked to get it, and the court providing you an opportunity to review it, and it was the exact same thing that you had gotten? You recall that in terms of reviewing and making sure that it was accurate and the state didn't do anything improper, is what I'm getting at.
I can't answer that yes or no. I can provide the context for that.
My question is, the bottom line, you reviewed that witness number 8, the recording that had been tendered to
Witness
Judge...
number 9.
I'm sorry, I apologize. Witness number 9, the recording that had been tendered to Judge Lester, and it turned out that the state had not misrepresented or done anything improper regarding that.
I don't think we were suggesting something improper. We wanted to be confident that since so much of the evidence was being protected and reviewed in camera, that it was complete. So that was to verify that, because we had real issues trying to identify how that process had taken place.
Okay, thank you. You made, you were asked questions regarding the interview conducted of witness number 8 in Miami, where she was sitting next to Ms. Fulton, correct?
Yes, I referenced that.
And you recall in a deposition asking witness number 8 about the circumstances regarding that,
Yes.
correct?
Uh-huh.
And you recall Ms. Fulton, you asking her, or Mr. O'Mara asking questions about that, correct?
I'm sorry, I don't remember that part of the deposition. It may have taken place, I just don't remember that.
You recall her deposition was at least 5 hours?
Oh, I think so.
Okay, maybe 6, 7 hours?
I don't
Almost
know.
all day?
Yes.
Okay, and you would agree, you're board certified, so is Mr. O'Mara, you all asked a bunch of questions of Ms. Fulton.
We absolutely,
Lived, how much money she made, how much money she had made in the past, all the way up to being present for witness number 8's interview?
I may have been confused. I thought you were asking me about the conversation at her home. That's what I was thinking about. Was she examined at length? Yes.
Okay. And I guess I'm trying to find out, maybe you can help me. You were asked about a memorandum that investigator T.C. Osteen did, and you said that the state was trying to hide information in that? That's your assertion, right? That's your allegation here?
Yes, I think so.
Okay. And so you believe under the rules that the state gave you that memorandum right away, right? There wasn't anything redacted from that memorandum, was there?
I don't have that in front of me. If you're asking me, was anything blacked out
Yes.
or whited out? No, I don't think so.
So what you're arguing to the court is that the state's not required to give in memorandums or memos to the file list everybody, that somehow is a discovery violation?
I think it's a discovery violation, yes.
And cite me what case law says that, sir?
It was intentionally withheld from us that the interview of this important witness was conducted in the presence of the mother of the young man that died.
Okay. And
It's
so-
completely misleading as to the atmosphere under which this witness gave her very first interview to law enforcement.
And that's your opinion.
It speaks
Again,
volumes
Chris, just answer the
about
question.
why the witness answered the way she did.
Okay. And so where's the discovery violation as to that? What Richardson hearing are we conducting regarding that? What point in terms of this Richardson hearing is there a prejudice to you and an intentional violation that other people were present and that was not disclosed to you and you feel you need it to be disclosed under discovery? Tell me what rule requires that to be disclosed? What case law requires that to be disclosed?
I think Rule 3.220 requires statements of witnesses and such.
Right? And so that was given to you. In fact, you were given the whole recording, correct?
Well, you know, the report was misleading. I don't have the problem except that it obviously was crafted to misrepresent what actually happened. And I say that because when you interviewed this witness, you did not identify Ms. Fulton as being present either. It was clearly an intentional act to hide the fact that there were family members and lawyers present during this interview. And I think that's a discovery violation. Yes, I do.
Okay, and so what case law are you providing to the court that says that's a discovery violation?
I think Rule 3.220 requires that. And I think, in all candor, the Code of Professional Responsibility also requires that.
Does the Code of Professional Responsibility also require that when defense attorneys meet with witnesses, they are supposed to disclose that to the state before the deposition of those witnesses?
No, I don't think so.
And why is that?
I don't know for sure what you're asking me.
Question is, isn't it true that you and Mr. O'Mara met with witnesses before the deposition? You didn't inform the state that you had talked to them before the deposition? Did you?
Are you talking about state witnesses, defense witnesses, or any?
Both.
I think that's commonly accepted practice. And you
Violation of your
engage
rule?
in that, we engage in that. It's to answer questions the witness might have prior to being deposed.
And in that purpose, are you required, if there was 3 other people in the room, are you required to disclose who those 3 other people were?
We aren't required to disclose the existence of that meeting in and of itself.
Thank you, sir.
At a deposition.
I apologize. I thought you were finished.
Well, at a deposition, counsel has the opportunity to inquire.
And didn't you avail yourself of that opportunity when you deposed witness number 8 and Ms. Fulton?
You mean in March?
Yes, sir. Let me make sure the record's clear. Does the state control what time you make a decision to depose a certain witness? Does the state control that?
I think in this case, yes, to some degree.
Oh, the state prohibited you from taking a deposition of witness number 8. Is that correct? Did we file a motion to that effect that you're prohibited from taking a deposition of witness number 8?
In my correspondence, I think it was September, when I was trying to identify discovery issues, as I recall, I specifically said, we need to get these matters addressed because it affects the deposition of important witnesses. Okay. We never got it addressed sufficiently to be able to have those depositions. We would have preferred to have had them well before March, frankly, but we've been fighting these discovery battles since the summer.
Let me be quite frank with you. Isn't it true that there's a money problem, too, in terms of the law firm or not getting enough money, and that's why there's been delays in taking the depositions?
No, I don't really think. Well, it's a two-part question. Is there a money problem? Yes. We don't have much. Is that why depositions were scheduled as they were? No, I don't think so. In that regard, I think your office has assisted us by having witnesses appear. It saved us money for subpoenas and such, and we appreciate that. We're trying to return the favor, so I don't think money really had much to do with that.
You agree that the court, I believe at least 1, if not 2 or 3 hearings, recommended, if not ordered, that you go to FDLE and get the actual documents from FDLE? Do you recall that being, those statements being made by the court? On several occasions?
My memory of that was that we had filed motions to compel and had complained about not receiving material that we thought existed.
But my question, with all due respect, sir,
Your
is...
Honor, he's in the middle of a sentence, and he has to be allowed to answer the question.
Okay, I'm going to allow Mr. De La Rondra to redirect the question.
My question specifically is, do you recall, it's not an explanation, you can, if you want to redirect, answer. My question is, do you recall the court, at least in 1 occasion, if not more, telling you and Mr. O'Mara to go to the FBI, to go to FDLE, and get whatever records you wanted directly from them?
Yes.
Okay. And did you avail yourself of that opportunity with FDLE?
Yes.
Okay. And did an attorney from FDLE bring out the entire file and provide it to you to copy whatever you felt you hadn't gotten already?
We were told that with a very narrow exception that we had the whole file.
Yes, sir. Regarding the thing about the hospital and witness number 8, witness number 8 was asked extensively about that, was she not, in the deposition?
Yes, I think so.
And witness number 8 stated, did she not, that this was a very emotional time for her? Did she not?
You referring to the issue
The
of...
hospital, the fact that a friend of hers had died,
Yes.
and that she didn't want to have to go look at the body, I think is the way she described it. Is that not true?
That's my memory as well.
And that she was very emotional in having to tell anyone, specifically the victim's mother, why she couldn't go to the funeral or to the wake because she just didn't want to have to deal with looking at the body, at Trayvon Martin's body there. Do you recall that?
That's what she said, yes.
And you believe that's exculpatory, right? That's going to prove the innocence of this man right here, the defendant. Is that your argument in the motion you filed?
I'm sorry, as a lawyer, that seems to be mixing apples and oranges.
Well, my
I think
question
that
is-
it is exculpatory in the sense that it is information that the prosecution has an obligation to disclose to the defense. I think there's ample legal authority. I think Brady v. Maryland, I think it's progeny, Kyles v. Whitley, and there's a lot of case law that says if there is information that would impeach a witness and the state's aware of it, they're required to disclose it.
Will that prove his innocence? Is that exculpatory?
That's my apples and oranges thing. Exculpatory means a lot more than just whether it goes to a critical fact upon which a jury would base guilty or not guilty. The overall assessment of the credibility of a witness, for example, clearly plays in to whether or not someone accused is ultimately found guilty. And to weigh witness 8's credibility, knowing that she had lied on what she thought was important anyway, I think is exculpatory and under our law and should have been disclosed.
And so that's why in the motion you allege that it was exculpatory, that it would prove his innocence. Correct?
It's exculpatory in legal parlance.
Okay. I apologize. Were you through? I didn't mean to cut you off. Thank you, sir. You had an opportunity in deposition to ask the witness about that, correct? Extensively.
Witness 8?
Yeah, I apologize. Yes, witness 8.
Yes.
And in fact, witness 8 wasn't just deposed once. She actually was asked to come back. I think she was questioned that Tuesday. She was asked to come back Friday. She showed up, came back Friday, and then you all didn't want to take her there or we ran out of time regardless, and she ended up coming a separate time, correct?
Yes,
Is
that's
that
right.
accurate?
It is.
Okay. And you extensively questioned that second time, I think 3 or 4 hours, correct?
Yes.
Okay. Now, you've asserted, when I say you, I can't remember if it was Mr. O'Mara or that followed the motion, but when I say you, I'm talking about the firm, if I could. You've asserted that you found out about there being no hospital records from Mr. Guy, correct?
Yes.
The night before the hearing, correct?
That's what Mr. O'Mara told me.
I want to make sure the record's clear. You didn't actually talk to Mr. Guy.
I did not.
Did Mr. O'Mara tell you that when he talked with Mr. Guy that evening, he said, oh, it's not a big deal, don't worry about it? You recall Mr. O'Mara telling you that? That he had told Mr. Guy, it wasn't a big deal, don't worry about it.
Mr. O'Mara told me what Mr. Guy said,
What I'm curious
but I
as to-
don't remember Mr. O'Mara telling me what his response was. No.
And do you recall the following day, then Mr. O'Mara telling Mr. Guy, when Mr. Guy brought it up again, he said, oh, hold on, that's Mr. West's issue. He's going to deal with it. You know, when I told you earlier that wasn't a big deal, Mr. West is not concerned about it. He's going to handle it. Do you recall conversation about that?
Right out here in the hallway? I think so, sure.
All right. So I guess overnight it became a big issue because you wanted to draw attention from the media standpoint that possibly witness 8 was lying about a non-material issue?
No.
Okay.
No, Mr. O'Mara told me that his conversation with Mr. Guy was to reveal that the hospital records wouldn't exist because she never went.
Okay.
And that Mr. Guy asked him, could we treat it with some sensitivity? And as Mr. O'Mara was relaying that to me, I got angry. To me, that was outrageous, because I suspected that the state had known about it a whole lot more longer than the day before, and Mark said, you deal with it.
Okay.
So the next day, I did. And I'm still angry about it, frankly,
Yes, sir.
the way that was handled. That's why we're here today.
Yes, sir. Thank you. Are you angry about the fact that the defense just listed, I think it was 200 witnesses, what, 2 weeks ago? Are you angry about that?
No, I'm not angry, specifically.
Well, if you could, since you're well-versed in the rules of criminal procedure, what does the rules of criminal procedure require for reciprocal discovery once a state tenders discovery to the defense? Isn't there like a 15-day period where the defense is supposed to respond?
That's, again, Rule 3.220.
Yes, sir.
And I think the state's obligation is a window. I think it might be even 15 days.
Okay.
And then after receipt, the defense has 15 days to respond.
So let me ask you this. Why did it take, over a year for the defense to respond to the state's? I mean, the state had filed by that time 15 supplementals, the original one, and 15 supplemental discoveries. Why did it take so long for the defense to figure out that they were going to disclose all these witnesses? Why didn't the defense disclose them 15 days after the original one, or at least after the first supplemental, or the second supplemental, or the third supplemental?
It's somewhat of a fluid process. The fact that the state has 15 supplemental discoveries, I think, establishes that it took 15 times so far for us to get the state's discovery. Each time we get another discovery disclosure, we not just look at what it is, but we evaluate everything with that additional information. The witnesses on our witness list includes witnesses that are also on the state's list. Those aren't 200, and I don't know that that's the number, but they aren't 200 new people.
Let's say 100. Let's say 100. I may have exaggerated 200. Let's say it's only 100, 150. And I can pull it up. I just didn't want to waste the court's time. But you agree that there was volumes of witnesses listed, correct?
Yes, I think the majority of them were witnesses known to the state, but it was more than 100, I'm sure of that, yes.
Between 100 and 200, let's say. Would you agree?
Okay, sure.
And my point is, why did it take so long for the defense to do the reciprocal discovery under the law? And should the state file a motion for sanctions for that?
As we investigated the case, identified witnesses that were on your witness list and took discovery, it's all part of this event that brings us here today. We never knew what we didn't know, and the state was not responsive to our requests. Most of the requests simply went unheeded until we filed a motion. So we got to the point where we didn't know what was coming, what wasn't being given to us, and what we might have to do to anticipate the worst, frankly. So I agree the witness list is voluminous, but because we have no idea how this is going to ultimately play out, we want to have the witnesses available should we choose to call them.
You listed over 40-something police officers, Sanford Police Department.
Yes.
Do you recall that? I can show you the document. Do you recall that? And you're saying a lot of them were already listed by the state, correct?
Oh, I think virtually all of them.
So why did it take you so long to list them as reciprocal discovery if you're required under the rules to list them within 15 days? If you had the reports and you already knew who they were, why did it take you so long? Or were you just trying to, at the last minute, do it to get some advantage?
In some respects, that's a non-issue, because using the Sanford police officers as an example, you know who all of those people are, you know what they're going to say. But we didn't want to run into a problem that if we wanted to call someone in response to evidence that was offered or an argument that was being propounded, that we would somehow be technically limited from calling that witness. So in that sense, we disclosed people that we may not call unless the circumstances of the trial would warrant it, and then we want to have those witnesses available. And that would include Sanford police officers. All sorts of outrageous, scurrilous statements have been made about that department and about some of those officers in particular. I don't know where this trial is going, but I think if those things are said in court, we want to have those guys available to us to take the stand.
And you agree that there was civilians, I want to say, well, we're all the way up to GZWFFF, so I guess, would you say maybe 70, at least 80, maybe 100 witnesses?
Yes, I don't know otherwise.
And why did it take so long to list all of those witnesses? It wasn't on purpose, I'm assuming, right? It wasn't intentional, like 4 weeks before, so then the state would have to hurry up and find out who these witnesses are, right? That wasn't intentional on your all's part, was it?
No, I don't think it was for that purpose. The court had set a deadline, and we tried as best we could to meet the deadline. We've now had to ask for some additional time as new witnesses are disclosed and revealed through investigation. And yes, there was sort of a line in the sand to get it done by then, and we did the best we could under the circumstances.
So is your statement then that you can disregard the rules of discovery because the court then made an issue in terms of, or stated an order, this is the deadline for witness list? You're saying you can just disregard 3.220 that requires the defense to disclose within 15 days? You're saying you can just disregard that and do it a year later?
No, as I mentioned, discovery is sort of an ongoing and fluid process. I would assume that between professionals, discovery would be handled in a professional way.
Yes, sir.
The state has filed at least 15 supplements, and a whole bunch of them last fall were reports that had been available to the state for months. So there was a decision made somewhere along the line not to give it to us, and then when we demanded it, to then finally disclose it. So is that what you mean? Is that okay?
I'm not going to argue with you, sir. My question is, well, let me address that specific issue. That additional discovery was after we met, after a court hearing. I told you I would check with FDLE and FBI and see if there was any additional reports, and I provided that to you all. Is that not true?
No.
Okay. But the bottom line is you agree that you all just listed on April 17th, 13 days ago, a bunch of new witnesses, and in fact, those witnesses, majority of them, the civilians, there was no reports about what they were going to say, correct?
Yes, that's right.
Okay. So the state has to spend money in terms of finding out who they are and tracking them down. Some of them don't even have addresses. Would you not agree with that statement?
No, they don't have addresses by what I believe is our agreement, but that's true, they don't.
Now, isn't it true that I had a conversation with Mr. O'Mara, and I asked Mr. O'Mara to reveal the address of at least a few of the witnesses that he just recently did, and Mr. O'Mara agreed to do that?
I don't know for sure, but that sounds right.
And
I don't think I was involved in that conversation.
Yes, sir. And no, I preface that because I don't believe you were. And would you be shocked to know that that hasn't still been complied with?
I don't know that I would be shocked.
Would you suggest, would you advise the state to file a motion for sanctions about that?
If you think there's been a discovery violation that would rise to that level, yes, I would suggest a phone call instead, but...
Okay. And, okay, thank you. I have no further questions, Your Honor. Thank you.
Thank you. Any redirect?
Just a bit, Your Honor. The enormity of the witness list provided, that included, did it not, all of the Sanford police officers and all of the Retreat View Circle people who had been previously victimized by burglaries in that subdivision. Is that correct?
I think those included the homeowners or the residents, as best we understood who they were, and investigating officers of reported crimes.
And do you know, in conversation with Mr. Del Rionda, that that was disclosed to him, that in an abundance of caution, we were identifying all the cops who responded and all the victims who had been victimized in Retreat View Circle?
I actually heard you say that. It was a phone call, and I believe you were talking to Mr. Del Rionda.
Okay. So that the 200 witnesses or so that he complains of or questions whether or not you and your expert opinion as a board-certified lawyer, whether or not that rises to the level of a discovery violation, was actually information that the state had fully available to them because they were the ones who had all of the burglary reports identified, correct?
I think we got that information from them, but it was otherwise publicly available, so yes.
Concerning the FDLE visit authorized by Judge Nelson, you recall that?
Yes.
Do you recall when that was?
It was January 9th of this year.
During that, did we find information there that relevant and potential exculpatory was yet to be forwarded by the State Attorney's Office to us?
I believe so.
What did that include? Now, as you answer that, I remind you that there are confidentiality privileges, and keep that in mind. Let me ask, was there a map that evidenced that Trayvon Martin, in his travels that night, was not simply in the area between Retreat View Circle and the 7-Eleven?
The map you're referring to, I believe, was a cell tower map, and that it was a report and map. I say report loosely because there wasn't actually a written report, but it was an analysis of cell tower activity with Trayvon Martin's phone on the evening of February 26th, and it showed where the signal bounced off of. And it showed that there was a tower that received a signal that was a considerable distance from the retreat at Twin Lakes that made us think.
I don't want to know what your personal opinions are.
But that information was found in the FDLE file, correct?
That was an analysis by an FDLE expert that was in the file that we had never seen before.
Was there also a stack of papers that included the entirety of the Sanford Police Department file that had been forwarded?
Yes, there was a file folder that had, I'm guessing, somewhat 150 pages maybe.
And did that information include information documenting criminal activity by Trayvon Martin that had not been previously disclosed to us? Yes. Nothing further, Your Honor.
Thank you. Any recross?
This alleged criminal activity turned out to be for naught, is that correct, sir? Because we just deposed those witnesses in Miami, and isn't it true that the school board members said it was not a crime? This allegation about a weapon was not a weapon under their criteria. Is that not true?
The report that Mr. O'Mara is referring to was a 7 or 8 page police report from the Miami-Dade.
I'm stopping this right now, this part of this questioning, because we're getting way beyond that which is alleged, and I don't need to go into those specifics. Are there any other questions on recross? Any questions on redirect?
No, Your Honor.
Okay, thank you very much, Mr. West. You may go ahead and take your seat. Any other witnesses from the defense?
No, Your Honor.
Any witnesses from the state?
No, Your Honor.
Okay, after the court has to make a determination of whether or not there's a discovery violation, and I haven't gone there yet, the next prong is to determine whether or not the defense is prejudiced by any of the alleged violations. The third one was what sanctions might avert any prejudice. So I need to know, how is the defense prejudiced by any alleged discovery violations?
Well, Part of it is actual, and we'll speak to that, and part of it is prophylactic. The actual is...
The prejudice has to be procedural prejudice. Not, the prejudice that has to be shown is procedural prejudice, not substantive prejudice.
Okay, I don't mean to misspeak when I'm about to say that what they're doing is they're not giving us information until we have to come before you each and every time we find a thread, pull on it until it unravels the state's deceit in giving us information, and it's particularly...
I need to know what a procedural process prejudice is.
We can't get ready for trial. We will be unprepared for trial because of everything that they have done to us. And unless you tell them to stop doing it and to play by the rules that they're supposed to play by...
Well, what you're seeking is monetary sanctions.
Correct. Actually, I want you to...
The procedural prejudice means that you're not ambushed at trial because the state withheld information that they're required to provide under 3.220 that caused you some prejudice at trial. Some of the examples in the cases that the court read were things like a witness had given a deposition and given specific information. One of them was that there was a gun under the victim's body, and the defense was led to believe that the victim may have been armed. Right before the deposition, or right before testimony in court, the state grabbed is my word, took that witness into another room and showed them a picture wherein the witness then learned from that picture that it was not a gun,
Correct.
It was a pager.
I know the case.
And that the defense didn't learn about that until the witness was on the witness stand. The court felt, rightfully so, that that was very improper because it was a procedural prejudice. The things that you're alleging as discovery violations have been cured. What is the prejudice, procedural prejudice by any violations? I haven't found violations yet, but if I were to, what is the procedural prejudice? We have 6 weeks before trial. You've taken the deposition of witness number 8. You found out before you took her deposition that she lied about being in the hospital. You took her deposition twice wherein you got all that information. You've gotten the information that you need. I could go over the LD FBI file. In fact, there was a subpoena ducis tecum for the FBI file, and there was some concern by this court that they had filed a response, and it has still to this date not been brought up for a hearing.
Staying on task then to the issue concerning whether or not, I guess I have to ask this court, whether or not discovery violations that haven't surprised us at trial are allowable. Because but for our vigilance and our diligence in bringing these issues before you, if you truly believe that what we brought here to you today doesn't evidence...
I want to make sure that I've got everything that you're alleging as a discovery violation. In all fairness, I wrote down, and I want to make sure I have them all. And these are my paraphrasing, not your words, so understand that. One of them is regarding the CD of witness number 8 that was provided by Mr. Crump. His interview with witness 8, that's one of them, correct?
Well, I will, to make sure that the court is aware, had the state done something to try and get...
I'm just trying to identify
the
issues. Okay. The next one is an ABC recording. The next of that same interview. The next one are discovery documents, CDs that were redacted with the witness's personal information, and that you had gotten, but then you had gotten the unredacted copies. The next one is regarding witness number 9. There was information that was not in the recording that was provided to the defense. The next one is the interview with witness number 8 in Miami, and the setting upon which that interview was held. The next one is the Osteen information. The next one is the FDLE and FBI information. And the next one is the hospital records regarding witness 8, the whole issue regarding the hospital records.
Yes, Your Honor.
Did I miss any of them?
I can't keep track.
Well, I'm trying my best to keep track.
I truly can't keep track.
Okay. Mr. West, did I miss any of them?
Yes, I think so.
What would I have missed?
If we're talking more broadly,
I'm missing what you brought, the defense brought this motion for sanctions, and I wanted to know if I missed any of them that I heard the testimony about today, because this is a Richardson hearing.
well, getting the photographs, getting the expert reports, getting good quality photographs that were connected with the expert reports so that we could depose the experts, learning about the reports at the deposition, the whole saga with the phone itself, learning about the data dump in October that we never knew or never got until some months later. There are, in fact, if the court would look at the correspondence that's attached to the motion, there are a number of issues there that are...
But a lot, those were not brought up in your motion. That correspondence was referred to, and you're referring to, starting with Exhibit number E and Exhibit F. Okay, in your motion, in paragraph 8, you refer to Exhibit number E, and this is regarding the misrepresentation about the hospitalization of witness number 8. Although Exhibit number E may have other discovery violations, the other ones that are listed were not referenced in your motion for that Exhibit E. Exhibit number F is the letter that you testified to in September. That was the follow-up to the previous email. And that is also referred to in your motion in paragraph number 9 regarding the hospitalization. It's further referred in paragraph 12, still in reference to the hospitalization. It is in reference to, in paragraph 15, regarding that hospitalization. It's referenced as to, in paragraph 19, where you repeatedly requested information from FDLE, DOJ, FBI. It's referenced in those are where it's referenced in. Exhibits E and F have other matters that are not referenced in your complaint, so they were not part of this motion in this hearing, this Richardson hearing. So other than what we've gone over and what's in your motion, were there any areas that this court missed from the testimony?
No, I don't recall any.
Okay, let's go to argument. Will you finish with your prejudice, the procedural prejudice?
Well, we've made this quite specific to the witness aid hospital records because we had to pick one rather than come to you and just complain about the last year. So we're here on that issue. And the procedural prejudice is that it has cost us hours and hours and hours of work. And very specifically, Mr. Delarianda knew on August 2nd that there were no hospital records. He knew that without question. And we asked him 2.5 weeks later, we asked him before that, but we can only prove that we asked him by letter testified to by Mr. West, and an email 3 weeks after that. And then we had more conversations. No answer. When he knew no hospital records existed. Then we filed a motion. In response to that motion, he did nothing. He did not call me up and say, don't waste your time, there are no hospital records. They waited until the night before when they say, let's use some sensitivity here. We'll bring out witness 9 and the absurdity that that has nothing to do with the relevance of this. But let's be a little bit sensitive to the fact that we've ignored your request for 4 months, 5 months, until you set a hearing. Now, the night before, we'll tell you, that is inappropriate, it's improper, and it's unethical. and I can cite you to rules of professional conduct, I can cite you to the creed of professionalism, and I can cite you to 3220. But it is absurd for a prosecutor to stand before you and say, you know, Judge, there's really no prejudice here because after all, they found out at some point, but I didn't have to tell them.
It's not the prosecutor asking, it's the case law that dictates to this court how to conduct this type
I
of proceeding.
agreed.
And the case law is very specific that there has to be a showing of procedural prejudice. So
I don't know that I agree with your premise that procedural prejudice has to be shown, Your Honor. What has to happen...
I'll refer you to Scipio, S-C-I-P-I-O versus State, 928 Southern 2nd, 1138, Supreme Court of Florida, 2006. And this case is, in the opinion and the dissent, is replete with references to that the rule is a finding of procedural...
No, I understand. I know the case. I don't know that I agree with your definition of procedural prejudice. If you're not
You define procedural prejudice as opposed to what they say substantive prejudice.
Procedural prejudice, if I have to go through filing motions before this court, if I have to go through additional efforts to find information that should otherwise be given to me by the state, which is obviously exculpatory.
That's the first problem. Okay, go ahead.
Then I think that what they have done has caused me procedural prejudice because of the workload that I have to take on because of this, and my ability to prepare this case properly for trial. Now, agreed, have I diminished their violation by our diligence? Yes. Should I have waited until trial, done nothing, and then come before you and go, they knew since August? And then you might say to me, did you ask them? Well, yeah. Did you write them a letter? No. I decided not to do that because that would be my diligence. So when do we get to the point where we actually start playing fair? When do we try this case on the merits and not on what's hidden in the shadows?
Well, thank you. Do you have any other arguments
No, Your
to
Honor.
that? State. Response.
Your Honor, the court has already cited the law, so I don't want to recite the law, but the bottom line is, and I'm not going to get into name calling at this time, I'm trying to adhere to the court's rulings or order that the court reminded us of. Witness number 8 was interviewed by the originally a sworn statement, which I provided to the defense. That was in April. In August, she was brought in. She was brought to Jacksonville, and she, as part of an interview of her, did, and I did not record that, she mentioned something to the effect of the hospital thing. It was just in passing. It wasn't, but she did say that she had lied about that. And Mr. O'Mara is correct. I did not inform them of that because, quite frankly, we forgot about it. That's why Mr. Guy, in handling the motion before the court the night before, called witness number 8 and said, these medical records, are there any there? And she said no. And as soon as we knew that, for sure, Mr. Guy contacted Mr. O'Mara that night. And Mr. O'Mara said it's not a big deal. But I understand that it's a big deal for them now. That is the bottom line how that occurred. Yes, it was inadvertent on my part. That is correctly. But I have provided extensive discovery in this case. I've attempted as best I can continuously provide discovery on this case. And so our bottom line is we continue to do so.
Just briefly, again, I guess my concern, I didn't make it clear earlier, was that I don't believe that this is simply a Richardson inquiry. I think you have an opportunity to control the way discovery is handled in front of you. We are here on a sanctions hearing because of the extra work that we had to do because of failings by the state. They have a discovery obligation. A Richardson inquiry is slightly different, and I agree that there would need to be, normally Richardson inquiries don't occur 6 weeks or 6 months before a trial. They come up as a matter of course when something is found out about. But you do have the inherent authority and ability to regulate how matters are going to be handled before this court. We've testified concerning the additional workload. We now know, although he now says that he simply forgot to do it, that he has an obligation beyond hiding behind memory loss. And I don't think that you should look at it and say, unless you allow me to say I forgot whenever I don't want to disclose something that would hurt my case. So the reality is we're professionals and we're supposed to act as such, and that he knew about information. And if he had forgotten about it and we reminded him in the middle of August, I was okay with that. If he had forgotten about it and we reminded him in September with the second correspondence, I'm okay with that. If he forgot about it and in the 5 other conversations he remembered it, I'm okay with that. I'm not okay with the suggestion that the day before they remembered to our detriment and to my client's detriment. Though he's not paying us right now, he's incurring a debt, and that debt is at $400 an hour, $350 an hour. You have affidavits as to that regard, and I'm asking for fees to be assessed as sanctions.
Thank you very much. To the extent that the Scipio case required this court to hold a Richardson hearing, I will address that first. Based upon the testimony heard today, the court does not make a finding that there was a discovery violation under 3.220B. 1A, it sets forth the state's obligations. 1B sets forth as follows. A statement of any person whose name is furnished is what is to be provided. Sure. A statement includes a written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or any manner made by the person and written or recorded or summarized in any writing or recorded. Interestingly, sections C and D of that same rule include oral statements. A and B do not. So the court finds that there was not a discovery violation. Also, there was no finding of prejudice to the defendant by the alleged violations in a Richardson proceeding. And there were no other sanctions suggested by the defense than monetary sanctions to avert any prejudice. That being said, the defense is seeking monetary damages in regards to the issues that were brought before the court today. The court will reserve on that issue and to a further hearing as to the time expended to be held at a proceeding post-trial. Okay, that gets us to the last motion we have here today, and this is the motion for sanctions regarding the Miami videos.
I believe the motion speaks for itself in that regard, Your Honor. Similarly, we sat around for 5 hours, and we were right, and unfortunately, it wasted 5 hours of time and expense. While the state's position is, well, they'll tell you that they didn't notice that it was set for video, though I think the attachments are quite specific. We did it the way we've done it. Though it was the first one, there were also significant witnesses that we decided to take.
Since I'm having a hearing post-trial on the other sanctions, why don't I reserve and have this hearing at that time also? That would be part of the entire, because Mr. West on the stand had indicated that he did not know how many hours that you were going to allege has been expended that you're seeking your sanctions for, and so I'll just include that in here because this is enough.
If you would like. I mean, the issue in this one is much more specific. It's 5 hours each because we sat there for 5 hours. So you can if you want to delay it, but that is what we're requesting. The affidavits suggest that. All the attached affidavits say that. We're seeking the time from 9 o'clock until, we actually got started about 2:40. So we're actually from 9 to 2 because we did have lunch in between, so I took off that time.
Well, part of that problem is this court was in, I don't remember if I was in trial or in an all-day hearing. And the call to my judicial assistant was, the message was just, there's some issues we need to discuss about the depots. I didn't get that message until I took a break on the bench, and usually, you could see from today, I really don't break. And I took a break because the attorneys wanted a 10-minute recess. I was told there was a call about some issues, and I said they can work out their own issues. I went back into court. It wasn't until after lunch that I was told that the issue was whether we're getting the depot started or not.
Yes, Your Honor. Which is why I'd offered the solution at the deposition to start with the videotaping, and then if you were to rule against us for some reason, the videotape would go to Mr. Delarion to be destroyed or whatever, and that was not acceptable. And that led to the 5-hour delay, or else we would have had 5 hours of deposition under our belt. You would have ruled in my favor, and it would have been fine, or you would have ruled in his favor, and we would have been fine. There was nothing on the tape itself, and nothing that the deponent ever said concerned about taking a video deposition. It seemed more to be Mr. Delarion.
And I understand what you're saying, but I feel more comfortable having this motion at the same time Post-trial is the other motion. We have another full-day hearing set for Tuesday, May 28th. And of course, the court expects that all of the matters set forth in the administrative order be followed in all future filings and court proceedings. Is there something else that you wanted to address before we recess?
Sorry. We are beyond your timeline for motions being heard, so you're giving us time after your deadline, and we're accepting...
As long as they're filed before my deadline, I will hear them after my deadline.
Okay. Two things. I have a very particular issue that's not been filed yet that will be filed soon that I think is going to take an extended amount of hearing time. We can address that now.
I could give you any Saturday you want. I just finished last Saturday spending from, what was it, 8:30 in the morning to 5:45 on an all-day Saturday hearing, so I can give you any Saturday.
I spent 9 to 6 Saturday and 9 to 9 Sunday
No,
at the
we're all
office.
working on
So
Saturdays, and
we're
it
okay
shouldn't
with
be a
that.
problem.
The question, do we want to address any of that now?
I don't want to give hearing time in addition to May 28th until I have motions filed. Because I find that I give the hearing time, and if the motions aren't filed, that...
Yes,
So,
Your Honor.
the motions according to the order dated October 29th, 2012. In fact, the order does say may be heard on or before May 31st, 2013. So May 28th is before May 31st.
Just so we're clear, and again, I appreciate you being willing to work with your order. What it says is all motions filed and heard by May 10th, and all sort of non-evidentiary motions filed by the 30th. So this is going to be an extended evidentiary hearing.
I don't know where, and I'm not bickering with you, but I'm just trying to see if we're operating off the same order. This is the amended scheduling order, administrative procedures. Paragraph 1B says, well, it would be 1. See, I misread it, and I apologize, and it does say pretrial motions shall be filed and heard before May 10th. They need to be filed before May 10th. I will hear them on May 28th.
Thank you.
Okay, thank you.
The only other issue is that we are quickly coming upon trial, and we're quickly coming upon jury issues. I don't know if there's an opportunity for us to meet, whether that has to be on record, but there are issues, I think, that we want to have some procedures. We've talked about numbers of jurors coming in, and I think we've...
Just let me ask Mr. DeLorando a question. Do you agree that procedurally that has to be on the record?
I agree that it does not have to be on the record.
Okay. Then I will find time to meet with you all. I think that at some point in time you were going to get together with any jury questionnaires that you wanted to present. I'd like to have those before we meet regarding jury issues. So,
any chance, since we have you for all day, that we can meet after lunch? Since they're here and we're here, and we'll go grab lunch and come back?
It's fine with the state. We don't have the proposed order or procedural stuff in terms of just giving the jurors, but I think we can accomplish a lot in a few hours. I agree.
I'm available.
That would be great, John.
Okay, so we will be in recess as to this case.
There is an order by stipulation that just needs to be addressed, Your Honor.
Okay, what
Apologize
is
for
that?
interrupting.
That's all right. And now,
Yeah, may I approach the bench?
please.
For the record, I have no objection to the order.
In order to inspect and photograph evidence, no objection to the form of the order?
That is correct.
Okay, what time is it? 1:30?
Should we
To
go to the
meet-
court's
1:30,
chambers, or?
In chambers, there's a conference room in there.
Thank you very much, Your Honor.
Okay, thank you. Court is in recess.